Please, your lordship, my lord, item number 11, admission matter. I have some personal difficulties, my lord, as I have to go to exam center.
Mr. Ayatarudar, 2 weeks. Item 11. Also is represented. Okay, 2 weeks.
Please, Lordship. In item number 28, Lordship, today only we could file one affidavit, Lordship. That may be called for.
Please, Your Lordship. I beg to mention item number 14, Your Lordship.
1-4.
1-4.
1-4, we have seen Mr. Atia, it's refused.
That's
Okay, no, I understand. Okay, but having seen you, we have to refuse her. Okay. What says I represented? On the prayer made by Miss, your name?
A. Chatya.
E.H. Atia. 2 weeks.
Lordship.
How's your health now? How's your health?
I have to go in every 6 months. Review my, the next term, July.
Okay.
Please, Lordship. My lord, I beg to upgrade item number 27, Lordship.
27.
Lordship, I am not in protection, Lordship, therefore I am praying for application, Lordship.
We'll see. I can't assure, but we'll see.
Lordship.
27.
Okay. 27.
my,
Sound appears to be low. Yes.
may it please, your lordship, my lord, I beg to mention item number 20 may kindly be adjourned, your lordship.
2-0.
2-0, your lordship.
Okay. A. Devan, Land Council. Okay, 2 weeks.
Please, Your Lordship. Lordship, I beg to upgrade item number 30, Lordship. Order maker.
3-0.
30. Yes, Lordship. This is an IA, Lordship.
Okay.
May I please, Lordship? My lord, I have prayer in item 24, my lord. My file got missing, my lord. I have searched a lot, my lord. And I have asked for the copy from my learned friend, my lord. But I may kindly be adjourned for 2 weeks, my lord.
Okay. Item 24, 2 weeks. Mr. Z. Hamad.
I'm deeply obliged, my lord.
May it please, your lordship. My lords, I beg to mention item number 22. My senior has some personal difficulty today. Kindly adjourn the matter.
Okay, 22. Your name?
R. Ghosh.
R.
Ghosh. Appearing for the
R.
GHUSH.
Okay. Item 22.
Diploma.
Item 22, Lordship.
22. May I
Yes.
Hello, I beg to mention,
Mention was made for 22. Yes.
I beg to mention item number 25 and 26, my lord. I'm paying for upgraded time.
Okay, we'll try to.
Must bless me.
Thank you, Lordship, my lord. Well, that your Lordship. That last time you will be there to remind your Lordship that
Item number?
item 34, I am for 34 and 37, my lord.
Yes. Last time you made a prayer, you were praying for bail.
Yes, my lord. Several times it came, madam. Ultimately,
Okay.
I think, madam, that it will be difficult for hearing, madam. So you also kindly consider, several times it came before your Lordship also, my lord. 4 or 5 times also.
Okay, we'll try to upgrade and take it up.
From 2, I think, a PSC matter.
APSC matters. will-
So prior to the possible
that.
12 or
After the motions, we'll upgrade those matters.
my lord. Obliged.
Item 1 for motion.
Even under page 32, my lord, dated 27/7/2023.
Page number
32.
32.
27/7/2023.
23. You have to wait for some time.
My lord.
Mr. A.W. Aman, Learned Counsel for the petitioner. Opinion is at page 32. Notice. Extra copies within 2 days. Call for the records. Prayer for bail shall be considered on receipt of tribunal's records. Okay.
Item 2,
Give a fixed date after 4 weeks.
Well, item 2 may be taken after some time. 22.
After some time. Okay. Yes, item 3.
item 3,
You may not, into an order at page number 91.
91.
Lord.
23.
23 opinion.
Order lordship.
23
We
or
have to wait for some time. Mr. H.A. Ahmed, Learned Counsel for the petitioner. Same order. Page 91 is the opinion dated 21 to 2023.
item 4,
Wait, please, lordship. Lordship. Time being told, yeah. 3 to notice sales, yeah.
Opinion at which page?
opinion is peace. A piece, no, see, the 79 is the operative part, lordship.
Which page is the opinion?
87, lordship.
87.
And the, we start from 82, lordship. Annexer 40, 24, lordship.
You'll have to wait for some time for bail.
Lordship, in this regard, lordship, opinion, lordship, the petitioner not continue the voter, lordship.
So whatever be the good reason, but since it is after a year, you'll have to wait for some time for bail. Same, Mr. R.C. Das, Learned Counsel for the petitioner. Opinion at page 82, dated 9/4/2024. Notice, extra copies within 2 days, call for the records. Prayer for bail shall be considered on receipt of records.
Lordship, the record are available, lordship, the previous EPP, lordship, writ petition, lordship, dismissed due to some clerical mistake, lordship.
I'm not getting you. Please repeat again.
Record are available, lordship.
Record is available. Where?
So, lordship, page number, lordship, 79, lordship. So 82, lordship, sorry. 82, lordship.
82 is the opinion.
Seventy, 79, lordship. Lordship, kindly find 79.
Hello, item 4 to the option.
So previous writ petition was dismissed lordship. And the operative part is 80 lordship. The 81 which is reflected lordship. The registered.
Oh, acha, okay.
1 month.
Okay. Then there is a, also as a representative, list this matter along with the records of WPC 5240 of 2024, comma, disposed of by order dated 29/4/2025. Okay, day after tomorrow.
Pass on.
Item 5,
Page 30, my lord, include order.
30,
30, my lord. It's 28/7/2023, my lord.
same.
My lord.
Mr. A.W. Amant and counsel for the petitioner. Opinion at page 30, 28/7/2023. Give a fixed date for whatever you are not giving bill, give a fixed date after 4 weeks.
Grateful, my lord.
Okay. Prayer for bill shall be considered on receipt of records. Item 6,
May I please have lordship, order at page 78.
78.
Yes.
Okay, you'll have to wait for some time for bail.
Lordship.
Come after a year.
Second round, no?
Mr. A. Ali,
Lordship.
counsel for the petitioner. Opinion in page 78, dated 26/2/2024. Same order. Prayer for bill shall be considered on receipt of records.
Item 6.
time being item 2,
Opinion at page
It's my lord, 13, my lord.
2016.
Lord. Notice was issued to another person, my lord. Notice I have annexed, my lord, page 16.
Page number
16, my lord. Ex parte, my lord. Notice served on 4/9/2015
Notice has
To-
been served to a family member,
to
lordship,
brother-in-law.
not to somebody who is not related to the family.
This is in violation of 231 and 2, my lord.
We're taking up a preliminary issue of maintainability along with we are calling for the records, but we are taking the plea of, you'll have to satisfy on the plea of maintainability. Heard Mr. R. Hussain, sorry, R. Ali, learned counsel for the petitioner. Respondents are there. The ex parte opinion dated 6/6/2016, passed by the London member, Foreigners Tribunal 4th, page 13, is said in this writ petition filed under Article 226 of the Constitution of India. As the opinion is assailed after almost 9 years. Commonly. Court is inclined to hear the learned counsel for the petition on the plea of maintainability. Next, in the meanwhile, the registry shall call for the records of FT 4th case number 50 of 2015, bracket SP inquiry number IM number 4835 of 98. This is at page 13 from the learned member, Foreigners Tribunal 4th, Dorok, Mongolway. Next, the registry shall issue the requisition to the following email address of the said learned tribunal. With liberty to the said learned tribunal to send the records, the scanned copy of the records, if the physical records cannot be sent. Full stop. Liberty is granted to the said learned tribunal to take the assistance of the Office of the Superintendent of Police, Border, Dorong, for facilitating scanning of the records. Next para list on. Give it after 3 weeks.
Twenty 25/6.
In the motion column.
6.
Yes, item 7.
These are lordships. The impute order is at page 111 lordship, starting from 111.
Page 111.
111 lordship, and the impute order was passed on 8/6/2023.
23. You have to wait for some time for bail.
Lordship,
And Mr. Z. Hussain, counsel for the petitioner. Respondents are there. The opinion is at page 111, dated 28/6/2023, asked by learned so-and-so in case number so-and-so, FT case number so-and-so. See, prayer for bail shall be considered on receipt of records.
wait for some date. Lordship.
It will get your date. All are on the same date. Date की है सर?
20 June.
20. Obliged.
So if the petition is apprehended, they will not be deported out of the country. In all the cases. Huh? Okay.
Lordship, obliged.
Yes, item 8.
Page 68 is the opinion, Lord.
Page number
68.
68.
Sorry, 62.
So 22 opinion.
Yes, Lord.
We have to wait for some time for bail.
Lord.
Mr. U. Datta and counsel for the petitioner. Opinion at page 62, dated 29/9/2022. Prayer for bill shall be considered on receipt of records. Same date we are giving.
Upgraded item 25.
Which page is the opinion?
$26. 52 page.
16 opinion.
16.
Huh?
16.
You are paying for bill.
Yes.
My insurance. Or 26 only.
Which is the best document you have to connect you to your projected parents?
1966 voter list, my lord.
Pardon me, please repeat again.
1966, my lord, voter list, page 24, my lord. Sarmon Sheikh, who is the grandfather of the Hopi, my lord. Zorullah is the father of the petitioner, my lord.
Yes, apart from voter list, any other document?
My lord. Then, my lord, 1989 voter list, where is the, my lord, along with his father, petitioner himself may be separed. my lord.
Where is your written statement?
Page 16, my lord. Very short written statement, my lord.
But there's a big gap between 1966 and 1989.
My lord. In between, my lord, 1970 also there, my lord, page 26, my lord.
Pardon me?
My lord.
Please repeat again.
Page 26, 1970. Serial number 218, Zorullah said. Zorullah.
Is this a exhibited document?
No, my lord. There is, my lord, uncertified, my lord. In this case, actually, what happened, my lord, after submitting written statement and WS, subsequent proceeding, my lord, not continued by the conducting counsel during trial, my lord.
there is some difficulties. Otherwise, my lord, petitioners have sufficient documents, my lord. In the 1989 voter list, along with his father, grandfather, petitioners himself may be secured. Trial is, my lord, not conducted properly, my lord. Ration card is there, my lord, revenue receipt. No, no, see.
First time your name appears in 70.
No, my name is first time appeared. 1989.
Hmm?
89. 1087.
At 42 years.
32.
89, I don't have the document. Which page are you referring to? 88. Oh, spelling is different.
Some particular page 30.
Written statement of equivalent, not a word, not a whisper. লাহে লাহে improve কৰি গৈছে আৰু কেছটো। Nineteen 56 of one. 1956 of one. Our first time vote was 89. At 42 years. নাই, no reason. নাই petition, WS তো একো নাই। WS বাফেকো নামো নাই। No name of anybody. Na sibling, na friend. Okay. তারপর দিলে আপনি সাপোর্ট পাই। আমি আজকে খালি না থাকে থাকো এই ফ্ল্যাটও তো ফ্ল্যাট তো ছিল না। কালী মন্দির মানে আগর যুদ্ধ আছে ডনবস্কোপার রাস্তা নামি যায় না निकलने एकदम ना था कल हमें मिस कर दो हम
Your documents don't match. So far as age is concerned, it doesn't match. Number one. Number two, your translation is mistaken. And that mistake is costing you, is at a huge cost to you.
Look.
The translation which you have made will entail a huge cost on you.
In which space?
You see, come to page 19.
19 my lord.
Mr. Sharma, please see this, page number 19. This is SMS, so I am asking you. Page 19, in the verification. But do you find age there? No.
No.
It's not there. Now come to page 17. Now you have made him 68.
17
Speak with your fate.
Yes, Lord.
If he is 68, nothing matches. Your petition is liable to be dismissed.
was not wrongly.
No, but who did it wrongly? We did not ask you. Did we call you up or HT call you up and said that do the mistake translation?
My lord.
We did not
It's
do
my-
it.
my problem. I may wait to this petition and petition.
No, you see, every time I say,
Otherwise,
please take care after drafting. We read everything. Not only we read the English, we read the Assamese also.
I may be allowed to file IA, my lord. Yes, this correction.
Do it.
This is my lord unintentionally.
No, please take care. It's not a question of intentional or unintentional. But it is, we told you it's costing you at a huge cost. Because when it comes to us, we read it. Now we find that when we read your brief, then also you are aggrieved. That why judge should read so much.
My lord.
If you don't read, then you will complain that the judge is not reading. Once we read, then you are in more difficult position.
Age part is not mentioned, my lord. This is not.
Not an age part. You see the trouble we are taking. We have to read English and Assamese and then find out what the document is about. And this is not the only case in a year which we have done. Every day we find mistakes like this. You don't take care. Then please tell us why should we?
The first time, my lord. Still, I'll never go.
Owing to incorrect, also as a represented, owing to incorrect translation of document, the Mr.
Okay, sir.
A.K. Azad, the counsel for the petitioner, prays for and is granted liberty to file an interrogatory application for correction. List as and when the interrogatory application is filed.
Also.
Upgraded item 26.
Lord, 26, my lord. Page 41 is the in opinion, my lord.
What is the best document you have to connect you to your parents?
In this case, my lord, page 47, paragraph 22 of the impugn opinion, my lord. Where is, my lord, mentioned that I was unable to establish the linkage with my father, my lord. Whereas in this case, my father recorded his statement at DW2, my lord. Before the trial.
Father's statement is DW2.
Yes, ma'am. DW2, my lord. Page 23, my lord. Petitioner's father, my lord.
Just a moment. Where is the certificate of the Gambura? There are
That was. Gambura certificates, my lord. It's not there. Gambura certificate is not there, my lord. Marriage certificate is there.
where is your affidavit? Your evidence, where is that?
Page 19.
19. Ms. Verma, we are sending you the records. there are two exhibits in the record which has a different numbering. We have not been able to locate that. Locate means correlate that. We'll take it up after some time. Let us go through the records. Some time. Item 27.
May I please, Your Lordship. My lord, impugned order at page 48, Lordship. In this case, documents are What if in this case, documents are not properly discussed and the evidence also not at all discussed also.
Whose evidence not discussed?
Lordship, DW 1, 2, and 3.
1, 2, and 3.
Yes. Not at all discussed in the impugned order, Lordship. And on this ground, earlier occasion, your Lordship was pleased to remand back one case. And the previous occasion, I also produced one of the order, Lordship, on 7-3, Lordship. That is on a record, Lordship.
Three witnesses were there.
Lordship.
3 witnesses were there.
Lordship, 3 witnesses are there. They adduced witness, but not at all discussed in the impugned order, Lordship. Only Lordship may kindly find at page 49, top 2 lines paragraph, Lordship. So and so are examined. Page 49. Nothing else, Lordship. Page 49, top 2 lines, Lordship. Okay, may I pass one order passed by your Lordship?
Just a moment.
Which order are you referring to?
Kindly paragraph 4.
Which is the evidence of DW 1, 2, and 3?
Lordship, DW 1, page 41, Lordship.
41.
Yes. Process of page 45.
Which judgment you are citing?
Oh, that was by this one. I believe. There are 4 में
Well,
candidates
keep
हैं,
us-
Lordship.
Keep us- You see, this order of 6687 which you are relying on will not help you, because in this case, we find that there is a reference to DW 1 and 2 at page 49. First line is the reference to evidence of DW 1 and 2.
Yes.
And DW 3, you'll find reference is made at page 50, last paragraph.
The present case lordship, his lordship, exhibit E and exhibit F. DW1 has been discussed in exhibit E lordship. The Gaubura certificate so and so was taken.
So the
into
tribunal
consideration.
says that exhibit A, B, and C
Yes,
does not show relationship with Adush Bepari. And DEF shows that she is the daughter of Adush Bepari. DW exhibit D remains unproved.
But lordship, relationships established by exhibit F lordship,
no,
and that is proved, and the
not
uh,
proved lordship. According to him, it is proved lordship, but the opinion says otherwise. Exhibit F, it says ration card also can't be taken into consideration as proof of relationship of OP with her father for more than one reason. Firstly, as per terms and conditions number 4, the family details have been declared by the beneficiary to pro forma 6C. Hence, whatever has been recorded in the family details, that was self-declaration of the OP herself. That apart, there is no mention of issue date on Exhibit F, though OP examined one Nobo Kumar Bora, Inspector of Food and Civil Supplies as DW3, and who exhibited one computerized list of beneficiaries with family details, white so and so. On careful perusal, it is found that the name of beneficiary is recorded as Sukuron Nesa, mother's name mentioned as Halimon Nesa, but the father's name is not mentioned. Hence, from the above, it can be said that there is every possibility that OP herself declared her family details in format C as per her requirement and used the same in this case to prove her relationship with her projected parents. Secondly, no person come forward to adduce evidence in favor of the OP. Hence, only on the basis of the family details of ration card can't be taken into consideration without corroboration of other witnesses or documents. All
approximately
has been discussed, lordship, in the opinion. What separate discussion my friend is seeking for, I'm not sure, lordship.
lordship may kindly see page 17, lordship, 47. The evidence of DW3 lordship regarding ration card.
So that has been discussed in the opinion, no?
Evidence of the DW3 is something and discussion is something else, lordship. Lordship may kindly see, it is very clear, lordship. May I read, lordship?
Yes.
I have appeared in this tribunal on receiving the summon. I am presently serving as an inspector of food and civil supplies, Bongaigaon. Exhibit F, ration card issued from our office. A selection list is prepared by the block video is the chairman. After preparation of list of beneficiaries, the same sent to the DC office for approval. After approval, the said list is sent to our office. Then we enter the name of beneficiaries and upload into our departmental computer in the RCM's MS portal. But the name of Sukaranasa is not found in the beneficiaries list as the software is changed and upgraded. Exhibit F1 availed from our departmental computer. Here it is very clear. This is prepared by video under the chairmanship of video. Then it is verified, sent to DC office. DC again sent back to the office of the food and civil supplies. Then the list is prepared, lordship. And why the list is not there, that is also mentioned here, because their software is changed and upgraded. This is the statement of the official respondent, lordship.
And petitioner's name is not found in the beneficiary list.
Why not? But something found from our departmental computer. Her name found from the departmental computer, but it is not available in the software because it is changed by the department, lordship. Lordship may kindly for a moment see page 46, evidence of Gaura, lordship.
Yes.
I am Gaubura of Revenue Circle, Village Dambari. Exhibit E was issued by me in favor of Sukuron Nessa. Exhibit E1 is my signature under objection. I personally know Sukuron Nessa from her childhood because we are from nearby village. The father name of Sukuron Nessa is Ardosh Ali. So she is known to the Gaubura from her childhood. He personally knows the petitioner lordship. And in the cross also lordship, I have not bring any document on the basis of which exhibit E was issued. As because due to flood, all relevant documents were damaged from my house. There is no office for Gaubura. We are working from our own house. No report submitted regarding the damage of document to DC office. Exhibit E, the certificate from printed by myself without any order from government. But the document which he preserved in his office, those are damaged due to flood lordship. That is also here. And the Gaubura knows the petitioner from his very childhood lordship. That is mentioned in his deposition lordship.
Authorized person to use. It will be जाएगा.
It is not a fact that the certificate was issued without any inquiry or without any documents. Because as he knows from very childhood, and the ration card which is exhibited before the learned tribunal at page 33 lordship. Page starts from page 31 lordship. Page 31. Lordship may kindly see there is name of the petitioner. Then her father's name, then her mother's name,
Ration
her husband's name also there.
not legible copy there. And read also. Sure.
There are similar other orders by this passed by this honorable court lordship regarding non-consideration of the evidences lordship. On this ground lordship, the honorable court was pleased to remand back the case for reconsideration.
What are the cases?
Okay.
Which are those cases?
Siddiq Ali lordship may kindly see paragraph 4. Paragraph 4 lordship Siddiq Ali. Yes, Lordship.
Yes, sir. Discuss for another.
The case 8296.
Lordship. Especially paragraph 7 may be seen in this case.
Yes, Mrs. Verma.
Lordship, my friend feels that the evidences have not been discussed, Lordship. But if Lordship comes to page 49, on top it says, there is in the opinion, it has been mentioned that both the DW1 and DW2 were examined. And the discussion is on page 50, Lordship, Exhibit E.
Yes, that you have already stated.
Yes, Lordship. And the Gaubura, knowing her, is not supported by any documents. The documents getting washed away in the floods at page 46, Lordship. But it was never reported to the deputy commissioner. So everything is a hearsay knowledge here, Lordship.
About DW1 Lordship, the learned tribunal is quite silent, Lordship.
DW1 is a procedure herself. And the documents have been discussed, Lordship.
We are reserving for the order. We are
Yes,
reserving the
Lordship.
matter for orders.
Yes, Lordship.
Mr. M. I. Hussain, and counsel for the petitioner. All the respondents are there. Is P. Balwan. Arguments concluded, judgment reserved. Judgment of the order reserved.
Yes, no problem.
DP obliged, Lordship.
There'll be some delay in the delivery of orders.
Upgraded item 30.
You know what? তোমালোকে ভুলকে দিছিলাম না গ্লাস টাইপের তো চেঞ্জ করবো না কপি আয় একটু নয়া মাত্র কারেকশন
This can't be amended. You'll have to withdraw it and file it afresh.
Yes,
This cannot be amended. The reason is that in the cost title you have given, you have projected yourself as a lady. In the affidavit also in support of the writ petition, same thing has come. So cost title also, but if we allow the cost title, then the affidavit is wrong.
Lordship, in written statement, his name is his father's name is stated as Mazam Ali.
No, no, I hope I have been able to communicate what we are trying to say. Please explain it to her.
you had first title in the writ. Look at copy. What is your? First title to do for support. To wipe the woman, son of family. Son of Mazamali. Lordship, her thing is the clause title itself is wrong.
No, no, cost title is wrong, but the affidavit in support of the writ petition, that is also same. Writ petition affidavit that contains the same mistake.
She'll have to withdraw, Lordship.
She has to withdraw and file it.
See, but on there is an order in 18/10/2023. They must grant it also.
The interim would be vacated now. That was oversight, Lordship. without. this
You've been given bail.
No, then the names are completely wrong. The names would go as per the petition
No,
lordship.
that's why that's the difficulty. He is a male, now shown as female.
He's the name. He's a male only.
No, no. But you see, it said wife of so and so.
of-
So male is projected as a female.
Female, yes.
Same mistake has happened in the affidavit,
And again
But
in the order also.
in the order also.
Yes.
So he has to withdraw and file it again.
Fresh, yes. So.
Because you can't be permitted to amend the affidavit. Affidavits are never amended. Therefore, you take a choice. You tell us at 2 o'clock, ask someone if you want to. You consult someone and then tell us, the best thing would be to withdraw it. You consult someone if you want to.
Because you cannot have a wrong petition also, no?
Next.
Upgraded item
He would like to withdraw lordship.
This is better. We are giving you liberty. Uh, You say, write it in the petition. Miss, your name? Miss M. Boral, and counsel for the petitioner, has submitted that there has been an inadvertent error in the cause title of the petitioner, which is also occurred in the affidavit filed in support of the writ petition. Next para, it is submitted that the petitioner is a male and son of late Majam M.A.J.A.M. Majam Ali. However, in the cause title of the writ petition as well as in the affidavit filed in support of the writ petition, the petitioner, namely Jasmat Jasmat Ali, is shown as wife of Raham Ali, Raham Ali, and daughter of Rakibul Hussain, Rakibul Hussain. And in the affidavit filed in support of the writ petition, Jasmat Ali Jasmat Ali is shown as wife of Raham Ali and daughter of Rakibul, Rakibul Hussain. Next, but it is submitted that a connected interlocutory application, which is registered as IA Civil 3691 of 2023, was filed for amendment of the cause title. Next, by having noted that there's also a mistake in the name of the petitioner as shown in the affidavit filed in support of the writ petition, she prays for liberty to withdraw the writ petition and to approach again. Next, for all the respondent presence. Next, in view of the statement that there is an inadvertent typing error in the cause title in the affidavit, court is inclined to allow the prayer. To stop, the matter stands dismissed on withdrawal with liberty to approach again. Next para. As the records are already received, comma, the registry shall retain the records for 30 days and thereafter return the records. We are granting you liberty to file again. We are granting you 30 days time for retaining of these records. If you file this petition within 30 days, the records will be available.
Time being item upgraded 26.
What is that exhibit H and F?
H lordship Gabura certificate
But why this
and
different marking here?
one exhibit 9. This is also
After exhibit 10, there is exhibit H and F.
yes, lordship. Why it was differently marked? I can know.
There is nothing on record.
No,
These two documents, my lord,
But these
exhibited-
two are not exhibited documents.
These
no.
two documents exhibited along with the evidence of BW. That's why there is different marks.
No, but DW did not give a different marking. In his evidence, there is no different marking.
No, I am wrong, my lord. No, my lord, I am.
And what do you say, Mr. Sharma?
Lordship. Otherwise, link is not established, my lord. They, and the persons who issued the certificate, lordship, never appeared before the tribunal, lordship. Lordship. And here is a lack of continuities of their lordship. And
I am relying, my lord.
on,
Relying on, my lord, the statement of BW two.
yes, lordship.
Petitioner's other deposed before the tribunal.
Yes, it is more important, lordship. Here I have seen in the record, lordship. Here, Jainal Akan, son of Rahman Sheikh, lordship, but he is relying on a voter list of 1989, lordship, where first time his father's name appeared, lordship, her father's name appeared at the age of 35 years. Here, lordship, Jainal Akan, son of Abdul, not Rahman Sheikh, lordship. These persons are, I think, lordship, not same in one person, lordship. And regarding that, lordship, no statement is there, lordship.
66, my lord, Abdul Rahman is there. In some voter lists, mentioned as Abdul, in some Abdul Rahman, in some Abdul Rahman. There is discrepancy in the name of the petitioner's grandfather. I'm trying to submit, my lord, on that point, my lord, at the time of final hearing, my lord. I will.
And lordship, what deposition DW1 has made, lordship, I am not aware and have not understood the contents written in the evidence in chief on affidavit, lordship. So that goes everything, lordship, what he has stated in evidence in chief, lordship.
At this stage, my lord, I am paying for bail and fix for final hearing, my lord. That time, my lord, I will review the point of getting discrepancy, my lord.
Lordship may finally heard the matter, and if lordship thinks it allow him to go on bail, lordship. If required, lordship, short death may be fixed, lordship.
In this case, my lord, advocate from the state side, my lord, there is
Pardon me?
my lord.
Pardon me, please repeat again.
My lord, there is no representation of the advocate from the state side, my lord. Page 41, my lord, impugn opinion, advocate for the petitioner is nil.
That is something between you and the your counsel. We have nothing to say. Because in this writ petition, you are not given, you are not stated about your conduct. Whether you went to the lawyers regularly, took the next date. Those about your conduct, you are silent.
Bail may be considered, my lord, as per my final hearing.
In your writ petition, what is the explanation about delay?
Paragraph 14, I have mentioned, my lord. Page 12. Though learned tribunal delivered opinion due to poverty, my lord, not knowing the consequences, she could not able to file the case immediately.
This is something very vague. This is absolutely vague. And definitely not a good ground for bail.
The point
She has been apprehended, or she is outside.
outside. The point of laying, my lord, I am relying on the deposition of others.
We are not satisfied with your explanation for delay. We are saying that you will not be deported if once you are apprehended. Your explanation for 7 years is not fully explained.
John Mallat may be allowed to file I for stating detailed reasons.
For that, you don't need an IE, you can file an affidavit. We'll accept that.
Affidavit.
Okay. Also is represented. Mr. A.K. Azad, learned counsel for the petitioner, prays for and is granted liberty to to support the statements made in the writ petition by filing an additional affidavit. Prayer is allowed. List the matter as and when the affidavit is filed. We'll take a short break and come back.
upgraded item 34 to 38.
But we have given a written note, my lord, whether it is available or not.
It's available.
Two things, one is written submission and another is list of dates, fine,
It's available.
my lord. But in this case, it came before lordship about five times, my lord. We have seen, my lord. Basic cases, my lord, we do not, the case is, but 2% died. But list of date kindly see, my lord. Date of occurrence is 21/6/99. Your lordship, I have given the note, it is there, my. FIR lodged after 2 days, my lord, 23/6/99. Informant, he is the own brother of the deceased. Now, name of the victim are Shahar Ali and Jahar Ali. Right.
What, in this, you are appearing for Lalchan Ali.
I am appearing for item number 34 and 37. 34 and 37.
Name of the accused?
Name of the accused, your lordship, Lalsan, Ohab and Jamal. And Izzat. 37 is Izzat Ali.
No, in your this list of dates.
It is only for item 34, man. Notice given for 34.
No. Here the accused numbers are there. I'm just asking from here.
Oh, I see.
That-
Oh, accused number, yes. I am here, my lord. Your lordship will find Lalsan, that is 7, 8 and 9. Item 34.
7,
7, 8 and 9.
8 and 9. But 10 is Lalchan Ali.
Lalsan Ali, Jamaluddin, Ohab Ali.
charge sheet.
No.
Charge sheet.
Yes.
Name mentioned in charge.
What frame charge sheet?
So 8, 9 and 10.
Yes. And item 4, accused number 4 is item 37, Izzat Ali.
Accused 4 is item 37.
Yes. 37. Here, madam, FIR total, my lord.
Just a moment.
Person names. Charge sheet 516%.
37 to 95. Is 8, 9 and 10. Because 8, 9 and 10 are appellants in which item?
34.
34. Yes. What are the date of arrest of this persons?
They have been, my lord, from the date of judgment, that is 28/6/23.
28/6/23.
28/6/23. About 2 years, one. Earlier, there were 3 months, one. Yes. One person out of this, my lord, one person, Habibur Rahman, he got bail, my lord. Accused number 6. First, I got the bill. Kindly see the FIR, my lord.
Is in your this notes
Yes.
list of date and the name of this one.
Another.
Serial number 4 is Jamal Sheikh.
But the 2 Jamals are there. Your lordship, kindly see, we have given in our note, in the written submission, my lord.
No. I'm just trying to see the accused persons. In page 2,
Yes,
you are referred trial court frame charges.
11 persons.
Yes, 10 persons here you have named.
Plus one Makbul Ali, my subsequently.
Plus one,
Makbul Ali.
Maqbul Ali.
Makbul Sheikh, who died on 21/5/15.
Died 21/5/18.
21/5/15, man. 1/5. So 10 person, my lord.
Okay. Now here the name, first page serial number 4 is Jamal Sheikh, J.
Serial number,
And in this, here there is item 10, who's Jamal Ali Sheikh. Now, which is right?
Muhammad. In the FIR, they have given Muhammad Jamal Sheikh. In the FIR.
Okay.
4, 10, same, man. Jamal Sheikh.
4 and 10 is same.
Same.
Same person, but names are.
Names are same, but the two different persons, but in the FIR, father's names was not given, man.
And there are two Jamal Sheikh.
Two Jamal Sheikh. We have mentioned in our note also.
And again, this serial number 8 is Abdul Wahab in the first page.
Yes.
In the second page, you have named him Wahab Ali.
Valid. That your lordship knows, my that the FIR is concerned, they have given, and his actual name is.
No, I don't know. Since I have not
But
looked
this
into
is
the
the
record, I'm
court's-
just asking you.
Court's matter. The
Okay.
court frame charge under, in the name of this person's mind.
Okay. Okay, please proceed.
But we have given by FIR names as well as the charge frame against this person. As it is mentioned in the order, mind.
But you see, to make it short,
Right.
in a series of orders, the Supreme Court has is now saying that what do you call, either 5 years or the custodial detention should be half of the sentence. But in 302, there cannot be a half of the sentence.
They are not on that mind.
So we can just expedite the hearing. That's all I think we can do at this stage.
That's why this order is coming again and again. Madam. I just for that purpose, madam, you're saying, madam. Your lordship is 1 year back. The idea rejection order is 1 year back, more than 1 year.
No, because this
So we are otherwise, madam, ready. It came for hearing also, madam.
because you'll have to give us 2 weeks time till we complete this what do you call this APSC matters. We are tentatively fixing a date for hearing in this matter, but only after the orders are dictated, then only we'll take up the hearing in this matter. We have no choice.
My lord, only that's true, madam. I appreciate your lordship because you understand how. your
Because
lordship-
once there are 50 matters we are taking up for hearing, and we have very limited time to hear the matter. So that's why we are taking up day-to-day basis. So you give us 2 weeks time and then we'll take up the hearing.
My lord, on merit, if you give just one order, I have given also annexed, my lord, along with your lordship. Just about 149, my lord. And a series of persons, 12 persons named in the FIR. Charge sheet filed against 16 persons. No, my lord, particular attribution was given to them, my. None of them. My. Your lordship, I have annexed on order, is it there, my lord? Is it? The legislature order, only 149 is Supreme Court allowed to go on date, my. Page 15 and 16, your lordship in my.
15 and 16 of the IA.
Yeah, no, not in the petition, my.
You can.
In the written submission, my lord, last page, your lordship,
Okay.
15 and 16.
No, this document is 10 pages only.
Oh, judgment, Supreme Court judgment is not good. Don't.
No, just check it up. This is what you have.
Oh, it will be there. This one. That will be good. Yeah. Another copy you are giving one. Yes, yes. Hmm? RDA rejection order, my lord, 12/1/24. Paragraph 11, my lord, you are page 96, 97, you are looking. In the IA. RDA rejection order, my lord. Your lord, there is a finding, my lord, it was there, my lord. Paragraph 11, page 95 to onward, my lord. Paragraph 11 is the relevant portion. In the IA. Paragraph 11, awesome. Thank you.
I'm not being able to follow. This interlocutory application before the Supreme Court of India, the the second page of the order, the name of the appellant before the Supreme Court is Merajul Islam, alias Muhammad Merajul Islam, alias Marazul Islam. Correct? In your in this write-up which you have given,
This, it is not this Mirajul Mal. This is another case. From
this is
this
another
Mal-
Mirajul.
So here another Mirajul Mal.
Oh,
Different case, man, not this case.
it's not in this case. Oh,
Not this case. No, not this case, man.
no, because we are not getting
No, I
things.
think, no, man, it is not this case. Man. This is different case, man. Just to show, man, that our role is very, man, nothing, not at all. So far, item 37, not a whisper, my lord, in anybody's. Ear. And otherwise also, my lord, 2 persons coming from jail, with whom, my lord, there is a murder case against one of my family, my lord. They came, and their sons and father, 11 and 12, they came and deposed. And informant says, my lord, he learned from PW2. PW2 says, no, he came to know that some miscreants they might have assaulted them. Wife of the deceased says, my lord, she heard that some miscreants,
We remember either you or Mr. Ahmed made that submission
my lord.
on the last
No,
occasion
your
when we
worship,
were hearing the
memory is
matter.
very sharp, so I more
No, no, no. My memory is very weak, but once you repeat it, then it comes back. Somebody may, either you or Mr. Ahmed, you made that submission.
But your worship is remembering, my lord. I
Yes,
think he
yes.
was there, my lord, at that time.
He was there. Oh, I guess. Remember.
Whole case is, actually there is a riot in between that, my lord.
2 or 3 witnesses came from the jail.
Two
and
persons.
2 persons, and then they deposed.
Another 2 persons are family members of the two jail person, my lord. And main period one side, one person, he did not support the case, man. On what basis, my lord? And for the last 2 years, they are, my lord.
I'm getting some recollection.
My lord. That's why you prefer this court because of memory much.
No, no.
I forget my case, my lord.
My memory is very weak.
They are that you are. PW8 is the wife of one of the deceased, my lord. She also did not support the case. She said these are not the person who are before the court now.
I can now remember.
Yes. Only PW8, my lord, wife of the deceased, we all kind of see what she said.
She does not identify.
Could not.
Mhm.
She said, madam, if I see, I can identify, but they were present.
They were
before.
present in the.
Exactly,
court,
sir. Wife of the one of the deceased.
Mr. Ahmed made that submission also.
Yes, yes. Well, lost. Yeah, my lord, now you are lost it.
It's only the that sentence.
Only,
What you call this 50% of sentence of 5 years. That is
Yes.
something which is troubling us.
that is another aspect. I am not on that, my lord. Here, actually, it is life sentence, my lord. 389, my lord, that is, we are not saying on that, my lord.
That is one more.
We are on
important
a
aspect of-
purely, my lord, it is a case of acquittal, my lord.
No, we understand that. Mr. Chaudhary, we are tentatively fixing the matter on 5th of June. It's a Thursday.
So it will come as a part heard, madam. That is, that.
No, no, we are not keeping it parted. We're not keeping it parted because, Mr. Chaudhary, we are more what you call burdened than you think of. This APSC matters till we
No,
continue
no,
the
we
hearing.
want the lordship
We-
to allow madam, madam, that's true.
Uh,
madam. But
we
only
will not
thing
be
is,
able
madam,
to.
this already your lordship had several times, that's why it will make.
No, no,
madam,
not parted.
this-
Parted is more headache.
Short date, my lord.
No, because unless we complete that, we will not be able to hear you. Mr. Chaudhary will not be able to hear you till this APSC hearing is over. After we reserve that, then perhaps we can start hearing another matter.
Can it be one day prior, because the Eid is on 6th, my lord. So that's why,
Then we make it 10th.
no, one day or 2 day prior to 6, can it be possible? I lift your lordship, my lord. I am not like, my lord, would like
No,
to,
because we have not yet completed that hearing. That is the troubling point. We don't want to fix it and then again adjourn it. Then 10th is a Tuesday.
then 5th, my lord. is-
Huh?
5th. I lift your lordship on your lordship convenience,
Mm.
maybe.
No, if it is Eid, then you will be difficulty. Before Eid, it will be difficult. Make it 10th.
10 is, my lord.
10th is Tuesday.
June 2.
Mr. H.R. Chaudhary, and Senior Counsel, assisted by Mr. A. Ahmed, and Counsel for the appellant, applicant. Next para, the learned Senior Counsel for the appellants has pressed the interlocutory application for suspension of prayer made in the interlocutory application for suspension of sentence. Full stop. Full stop. We propose to upgrade the hearing of the connected appeal as it would, as there are 20 PWs and 4 DWs to be examined. Oh, sorry, six DWs to be examined, even for the prayer for bail. Expect accordingly. List the matter for hearing on 10/6/2025. Next para, it is clarified that the interlocutory application for suspension of sentence is pending. The prayer made therein may be pressed on the next date of hearing.
If the appeal is not taken up.
Yes, if the appeal is not heard for any reason whatsoever.
My lord, one thing in this case, one of the case, I think about juvenile returning. It's agreed with this. Oh, that is.
One was juvenile, we sent it back
That
to
is-
examination before the
Then no.
trial court for determination whether he's a juvenile. What happened there?
They are actually, my lord, birth certificate did not support the accused. So it is gone for ossification test. Report has not come. Tribunal AK Buya is appearing for that case.
Just what happens in SH Bora, APP.
বহীখন উলিয়াই লৈছো এইটো ফৰ এডমিশ্যন এইটো দেখিছে 51740 হয় ন ফৰ এডমিশ্যন Item 9 for admission.
May please your lordship. But here in this case, my lord, I have gone through the records. On the basis of the records, my lord, I have the submission on the quick maintainability of the proceeding. The inquiry officer has visited, as per their case diary, visited, statement recorded, but no signature was taken by the police officer from the witnesses. This goes to show that there was no inquiry. That was the plea of the petitioner. In his oral deposition, he has claimed that police did not visit it for inquiry. So that is my preliminary submission. And in the light of the full bench decision, paragraph 97, there has been an indication that for ensuring the inquiry, proper inquiry, police, the inquiry officer should take signature or thumb impression, whatever, by the inquiry officer. That has not been taken. And what has been prevented to take signature or thumb impression, that has also not indicated in the inquiry report. Then, my lord,
In one of the cases, we have discussed the issue. You see, what happens is that these police people are always trained to record the statement and not to take signature because that is not permissible under the CRPC. Now, out of these people, some people are deported to border police. And when they inquire, they are not well trained to record this, to take the signature of the statement. So that is a mistake. It happened. We made an inquiry, and nobody knew in the police that they were required to take statement
my lord,
under the signature.
my lord.
So that is a practical difficulty because of the fact that
Pardon of the state, my lord, this is a separate proceeding.
no, we understand.
That is the view of the full bench judgment. That has not been followed, my lord. So the inquiry conducted against the petitioner has amounted violation of fundamental rights, my lord. Right to defense at the investigation stage, that has been violated. That is the opinion of the full bench decision in paragraph 97. Then, my lord, here, my lord, admittedly there is shifting. That has been also claimed by the proceeding, but his father is voter, my lord, and also having entry in the NRC 1951. That has been also produced before the tribunal. The NRC of 1951. In the record, my lord, the NRC in my petition also, we have annexed the NRC. It will legacy. My lord, page 62 is the NRC of the record, my lord, 1951 NRC. Father's name is at serial number 12, Dukhi Roy. My lord, variation is there somewhere, my lord, Dukhi Roy, somewhere Dukhilal Roy. 66 voter list and 70 voter list, father's name is available. Dukhilal Roy. But subsequently, my lord, against the name of the petitioner, his father's name is written as Dukhiram. So this type of variation, my lord, cannot be fatal to the prime evidence, my lord.
Which are the documents exhibited by you and what is
My
your
lord,
written statement?
Voter list of 1966 and 70. Voter list of 1966 has been exhibited as exhibit A. Somewhere exhibit A, somewhere exhibit 1. I have seen in the record, my lord, exhibit A, voter list of 66. Then, my lord, voter list of 1970 is exhibit 3, page 24. 66 voter list, page 23. And voter ID has been exhibited as page 55, voter ID. Exhibit 1.
Just a moment. So Sharma, something we're not being able to follow. Are you sending in the records?
The learned tribunal hold a view that the voter list, original brutalist is not produced.
No, it's not produced.
Original brutalist, my lord, certificate copies you have produced the prime documents, 60, 70 brutalist.
We don't know, we're not
asking
being able
about
to
copies,
follow
my
this, sending it back.
lord.
Just look at this record.
My lord,
You see, from the evidence on affidavit, we don't find any document marked as exhibit.
Yes, Lord.
Now in this, there are few documents which are exhibited and marked by the tribunal. But how did the tribunal choose what documents to mark as exhibit? There's no corresponding order. There's a cross-examination where also the documents are not marked.
Double marking is there, Lord. Double marking is there, Lord.
You see, the query is if the person is not exhibited
Yes.
and the
yes.
court has marked some documents as exhibit, what is
Yes.
the basis of making those as exhibits?
But order ventilates that most of the documents are not exhibited, Lordship.
No, we understand, but you see, if
Yes.
the document is not exhibited, all documents are not exhibited.
Yes, yes. Lord.
How did the tribunal choose one or two, five,
Yes,
or
yes,
four,
Lord.
five? How did that happen? Corresponding entries we are not finding in the order sheet.
Yes, Lord.
You go through it, we'll take it up day after tomorrow.
Lord.
You examine the records, we'll take it up
Lord.
day after tomorrow.
And tribunal also hold a view that brutalist are
Let him examine the
produced-
records because
my lord.
also is represented on the prayer made by Mr. G. Sharma, and it's standing also for the FT matters, the records of the tribunal is handed over to him for perusal and to address the court. List on day after tomorrow.
So am I allowed to retain?
Yes, we are permitting you to retain it.
Division bench item 42 to 89 for hearing.
Other item number
81.
81, no?
That's I was addressing your lordships on the last occasion, my lord, on Friday. On writ appeal number 14 of 2022. I represent, my lords, a lady called Suranjita Hajarika. She was, my lords, a district transport officer. She was under probation. She had, my lords, completed her initial period of probation. There is no adverse report against this officer, my lord. Till, my lords, she was not named in the Dibrugarh police station FIR, my lords. She was arrested on 18/7/18. But I'll hand over a list of it. I'm just giving a flavor. Subsequently, she was released on bail. She is named as an accused, my lords, in supplementary charge sheet number 6 as accused number 54. So, my lords, after her release, this case has a background. She moved this honorable court. Her writ petition was filed, my lords, on 9th January 2019. And the writ petition was filed because she was not allowed to join her services. So a declaration was sought, my lords, that she continues to be a member of the service. That writ petition, my lords, came up before the learned single judge, my lords, Justice Koteshwar Singh, as his lordship's then was, and an order was passed, my lords, on 11/1/19. That order, your lordships will kindly have at 246, my lords, because this has a background, my lords. At page
Last
2.
time you made the submission, you said that it is after that that the discharge order came on 21 January.
So that order, my lords, in fact, records the apprehension of the council, of the senior counsel appearing for the petitioner, my lords, stating that they may take action, my lords, to discharge without following the due process. Justice Koteshwar Singh said, my lords, that the apprehension of the petitioner is that the petitioner's services may be discharged without following the due process of law. It goes without saying that the authority will have to abide by the law before discharging any person from service. But this order, my lords, is served on the department on 14/1/19. And on 21/1/19, my lords,
You were discharged.
the discharge order is passed. The lordships have seen, my lords, the discharge order. It is an exercise of jurisdiction and power under Rule 19, my lords, of the Assam Transport Service rules. I had made my submission on the last day, my lords, that Rule 19, my lords, one will not apply on the face of it because, my lords, when we read the order itself, there is no allegation that, my lords, she was found wanting, my lords, during her period of probation or during the period of training, my lords. There is no such allegation. So, my lords, it will fall under 19(2) at best. And 19(2), my lords, to be triggered, your lordships had seen the language, my lords, that it is found on a subsequent verification. So, my lords, this subsequent verification is after the officer has entered the service. So, my lords, this is a verification after the officer has joined the service, when the officer is in employment, my lords, of the government. And this subsequent verification, my lords, in my respectful submission, my lords, is nothing but an inquiry. And if it is an inquiry, my lords, it cannot be ex parte. That was my submission, my lords. I had also submitted, my lords, that not initially qualified, my lords, would mean, my lords, the circumstances mentioned in 7, 8, 9, I pointed that out, my lords, or that he had furnished any incorrect information with regard to her appointment.
You had referred to 7 to 10.
Yes, my lords, 7 to 10. I'm grateful, my lords. So, my lords, my submission was, my lords, and I'll make it good, that Rule 19(2), my lords, or Rule 19 for that matter, or the Assam Transport Service rules does not, my lords, exclude expressly the principles of natural justice. There is no express exclusion. There is no implied exclusion either. So in my respectful submission, my lords, on the plain reading of 19(2), when that subsequent verification is conducted, my lords, verification is nothing but an inquiry or an investigation. Well, I'll place the definitions, my lords, that it is nothing but an inquiry. And when you conduct this inquiry, my lords, the officer concerned will have to be heard. Secondly, my lords, there is a presumption, my lords, your lordships knows, my lords, under section of 114E of the Indian Evidence Act, that official acts have been regularly performed. So in this subsequent verification process, if that presumption is to be dislodged, namely, my lords, that there was some hanky-panky in your appointment, that you entered the service by unlawful means, and in this verification process, my lords, when the employer holds that there was something wrong, my lords, namely, my lords, their appointment orders have been issued either on a mistake of fact or on a mistake of law, or that he or she was not initially qualified, my lords. In this process also, my lords, the employee will have to come in, my lords. The employee will have to be heard, my lords. Law does not, my lords, in my respectful submission, permit any ex parte determination, not to the detriment of an officer. That's my respectful submission, my lords. And in case, my lords, there is a silence in the statute, I respectfully submitted, my lords, relying on Justice Biles, my lords, famous epigram, my lords, in Coopers versus Wondward, that the justice of the common law will apply, my lords, to the omission of the statute. And this has been repeatedly followed by the Honorable Supreme Court, my lords. It's a very beautiful, I'll place that, my lords. Good language, very lucid, my lords. That the justice of the common law will supply the omission of the legislature. In Mohinder Singh Gill's case, my lords, even Justice Krishna has said that the silence of a statute has no exclusionary effect, my lords. You cannot exclude it because the statute is silent. So if there are gaps, my lords, in the rule itself, that gap will have to be filled in, my lords, by the justice of the common law. My lords, principles of natural justice is nothing but fairness in action. It's fairness. What matters, my lords, is not, my lords, the character of the authority deciding whether it is a judicial act or a quasi-judicial act or an administrative act. After Binapani Day, my lords, followed by A.K. Kripak, even administrative authority, my lords, when it passes an order which is, my lords, prejudicial to the interest of a citizen, which adversely and prejudicially affects the citizen, an order which has civil consequences, hearing is mandatory. It is not a matter of convenience, my lords. It cannot be. And in fact, my lords, Professor Wade, my lords, in his textbook says that convenience and justice are not in speaking terms. It can never be in speaking terms, my lord. You cannot say, my lord, for convenience sake, I am dispensing with principles of natural justice. In fact, the phrase is convenience and justice are not in speaking terms. And my lords, the decided cases have said that breach of natural justice renders the order void, not even voidable, my lords. It renders the order void. Though, my lord, yes, my lord. The lordships want
In
to
your
say
submissions, it reminded me of Charles Dickens. There's a character, Oliver Twist. In that, there is Mr. Bumble. And he says, if law says so, then law is an ass.
Lordship can quote that, none of us.
So, my lords, though, my lords, in the additional affidavit, their first affidavit in opposition came, that was followed by an additional affidavit, where, my lords, in my respectful submission, the state tried to make a tectonic shift, my lord, in their stand. Whether that is permissible or not, my lord, it is for lordships to consider, my lord. I'll make good my submission. No leave was applied for or granted, my lord, by the single judge. But in that affidavit, my lord, your lordships knows, my lord, when you write more, you disclose more. So there are lots which come out from that affidavit. That affidavit shows that a preliminary inquiry was conducted, my lords, against the appellant. That preliminary inquiry was behind the back of the appellant. Two places they refer to a preliminary inquiry. Secondly, my lords, there is a without prejudice argument. Lordships, open the paper book here, my lords, page 286. 286. My lords, has that? Your ladyship, page 286. Without prejudice, your lordship will see this. Without prejudice to the above, it is most respectfully submitted that in terms of the proviso of Article 311, this is proviso B, if recall, whenever it is observed that it is not reasonably practicable to hold any such inquiry, envisaged under Article 311(2), it will not be necessary to give such person any opportunity of making representation, and the said provision shall not apply. In the present case, having regard to the material which has been available during the detailed and thorough investigation been carried out by the Assam Police, where the beneficiaries of the colossal fraud in the recruitment process have been found to be unfit to service, it had been found, please mark this, Madam, it had been found not to be reasonably practicable to hold any inquiry. As such, the proviso B to Article 311(2) squarely applies in the present case. And this, my lords, is again reiterated, my lords, at para 77, page 293. So, my lord, they have invoked the second proviso to Article 311(2) to suggest, my lords, and I must tell your lordships, my lord, this is a very dishonest stand from the state. Because the deponent should be pulled up for this. He's giving an impression to your lordships that we have dispensed with the hearing because under 311(2) proviso, second proviso, it is not reasonably practicable to hold the inquiry. And this is reiterated, just have para 77 at 293.
Yeah,
The lordships have seen that?
yes.
Will your lordships have, my lords?
Which part? Which part of that paragraph?
Just give me a moment. 293, my lords. Third para, my lord, without prejudice to the above, lordships has that, my lord. It is most respectfully submitted that in terms of the proviso to Article 311, whenever it is observed that it is not reasonably practicable to hold any such inquiry envisaged under Article 311(2), the said provision shall not apply. In the present case, having regard to the material which has become available during the detailed and thorough investigation been carried out by the Assam Police, where the beneficiaries of the colossal fraud in the recruitment process have been found to be unfit to service in public offices, it has not been reasonably practicable to hold any inquiry. As such, proviso B to Article 311(2) squarely applies in the present case. Any contention to the contrary is unsustainable in law and deserves to be rejected. The losses will come back to page 249, the discharge order. So the state has to be fair, They can't, play ducks and drakes with a court. They can't, it's not a game of chess. That if not this move, then this move. Just please have 249, There is no mention, there is no mention of an order in writing that the state has dispensed with the inquiry because it is reasonably not practicable to hold the inquiry. And I will place Tulsiram Patel's judgment, which says that the reasons in writing will have to be disclosed. It has to be in writing in the order itself. And it is mandatory to record such reasons, Will the lordships have 311(2), Article 311? Now, the state's case is something. Where is it? Three 311(2) second proviso, Your Ladyship, I'm referring to Article 311. It will be running page 134. Next page. No such person, my lords, has 311. No such person as aforesaid shall be. May I read one also, 311(1)? Please. Dismissal, removal, or reduction in rank of persons employed in civil capacities under the union or the state. No person who is a member of a civil service of the union, or an all India service or a civil service of a state, or holds a civil post under the union or a state, shall be dismissed or removed by an authority subordinate to that by which he was appointed. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. I pause here for a moment, my lords. Single judge, your lordships recall, my lords, has made a distinction between pre-recruitment anomalies and post-recruitment. And the finding is, my lords, that pre-recruitment anomalies does not fall within the definition of misconduct as understood in service jurisprudence. My respectful submission is, my lord, Article 311 does not use the word misconduct. It says no person shall be removed, discharged, or reduced in rank except after an inquiry. And 2 says the charges should be made known to the officer. Please have the second proviso. I'll read the first proviso also. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person an opportunity of making representation on the penalty proposed. So for the penalty, he may not be heard. Please have the second proviso. Provided further that this clause shall not apply where a person is dismissed or reduced in rank on the ground of conduct which has led to his conviction in the criminal charge, or where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied. Please mark, my lords, that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. And where the precedent of the governor, as the case may be satisfied in the interest of the security of the state, it is not expedient to hold such inquiry. In the subclause 3, my lords. If in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2. The decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. So, my lords, whether it is reasonably, my lords, probably practicable to hold the inquiry, that decision the court says is final. But the file must disclose. And not only the file, my lords, Tulsiram Patel says that the order itself must disclose in writing that it is not reasonably practicable to hold the inquiry. Right, my lord? The order your lordships have seen at page 249 does not invoke Article 311, second proviso to 2. So, my lords, this is a very unfair state of the state to say that we have dispensed with this inquiry because it is reasonably impracticable to hold so. And my respectful submission is this, my lord. This argument, my lord, cannot be a without prejudice argument, my lord. This can't be a without prejudice argument. My lord. It's an argument on jurisdiction. You have to tell the court that we don't want to give him a hearing because it is not reasonably practicable. So it is their case, my lords. Pleaded case is, it is not that we have invoked Article 311(2). Records are not placed, my lords, before the court. And in fact, my Tulsiram Patel says that the order must disclose that 311(2) second proviso has been invoked. Your lordship is looking for. No, you continue. No, my lords. The other limb of my argument was, my lords, that the order, my lord, when your lordships test the legality of the order will have to be read, my lords, in terms of the language used in the order. Because they are trying to improvise. Somewhere they say, my lords, that we found the appellant unworthy because her during the training period, my lords, her services were not up to the mark. Somewhere they, my lords, they refer to the police case.
Mr. Chaudhary, it is a very on this submission.
Yes, ma'am.
You see, without prejudice is something we understand in normal legal parlance is a statement made without intending to
bind.
be an admission.
To bind, yes.
Correct.
I'm grateful.
So once somebody says that it's not an admission, the state here says that it's not an admission. They are making a submission without prejudice. The intention is only one, not to bind them. So therefore, the other defenses are other defenses which you have taken will continue, and it will not be in prejudice to this statement.
My lord, said it, my lords, that this cannot be a without prejudice argument. The decision to dispense with the inquiry under 311(2), my lords, in my respectful submission, my lords, cannot be a without prejudice argument. Because this goes to the jurisdiction, my lords, it goes to the authority of the person passing the order that we have decided not to give you. In which case, your lordships will then test it on the parameters, my lords, whether it is reasonably practicable or not.
That's where the question is. You see, it's one thing to say
Yes, ma'am.
that 311B must be a self-contained order,
Yes.
2B.
Yes,
That's what your argument is.
Yes, ma'am.
So that's one part.
Yes, ma'am.
The second part is, without prejudice would always refer to statement made elsewhere. So even if it is contradictory, this is without prejudice. So one cannot say now that, well, you have taken this plea and therefore there is an ouster of another plea. That is what I understand with
Yes,
that.
your lordship is right, my lord. Without prejudice, my lords, an offer, my lord, supposing I make a without prejudice offer to my learned friend. Moment she accepts that offer, my lord, that without prejudice becomes binding on me. If she doesn't accept, my lord, the law is, my lord, there are some decisions which says without prejudice offer once accepted becomes binding. But till it is accepted, but in pleadings in court, my lord, what I'm saying is this.
But this won't happen. This won't happen here.
But pleadings in court, there's some sanctity. You can't play ducks and drakes with the court. And please see, my lord, the without prejudice submission at page 285 once again, my lord. Just see it, my lord.
Yes.
Page 286.
Yes.
In the present case, the second part, my lord. The first part, my lord, I can understand, my lord, it's a submission in law that you've just given it. If the court takes it, very good. In any case, we are through. The second part, my lord, in the present case, it's a statement of fact, my lord, having regard to the material which has become available during the detailed and thorough investigation being carried out by the Assam police, where the beneficiaries of the colossal fraud in the recruitment process have been found to be unfitted to service in public offices. It had been found, my lord, please mark this, my lord, as a statement of fact, my lord, it had been found not to be reasonably practicable to hold any inquiry, and as such, proviso B to Article 311(2) squarely applies in the present case. Any contention to the contrary is unsustainable in law and deserves to be rejected. Well, first, my lords, one can understand, my lords, without prejudice, a legal argument is made. If it attracts the court, my lords, well and fine. If it doesn't, it's okay. It's a without prejudice argument. But the second part, my lords, it's a statement of fact that in the present case, having regard to the material, so they are saying that we have in fact invoked 311(2). Then my respectful submission is, my lords, the order does not record that they have invoked Article 311(2) second proviso B. The order, my lords, is completely silent. And Union of India versus Tulsi Ram Patel, my lords, this is the landmark judgment under Article 311, my lords. 1985, 3 SCC 398.
Just a moment.
I will place that, my lord. Don't have it. I will place that, my lords.
Just a moment. I've made a sequence of events for lordship's convenience. If lordships come to page 8, my lords. I've handed over a copy to Mr. Kohli, my lords, through my Delhi office. I hope he has received it. My lords, kindly come to page 8, my lords. Put out the page. Without prejudice, my lords, has that? Your ladyship, page 8. Without prejudice, it was contended by the state respondents that it was not reasonably practicable to hold any such inquiry as envisaged under Article 311(2) of the Constitution of India, and hence it will not be necessary to give such person any opportunity of representation, and the said provision shall not apply. The said position is also reiterated in para 77, page 293. This contention is expressly untenable, as the decision that it is not reasonably practicable to hold such inquiry cannot be a without prejudice argument. That's what I stated. It is the requirement of clause B of the second proviso to Article 311(2)
that the reasons for satisfaction that it is not reasonably practicable to hold such inquiry must be in writing, and such reasons in writing ought to have been recorded in the discharge order itself. As held in Union of India versus Tulsiram Patel at page 505 minutes, that for the valid application of clause B of second proviso, this is from the judgment itself, it is mandatory for the disciplinary, please mark this minutes, for the disciplinary authority to record in writing its reasons for its satisfaction that it was not reasonably practicable to hold an inquiry as contemplated under Article 311(2).
This is 1985, 3 SCC 398. Para 133.
133. Losses want to have a look, my lord?
You're getting it.
Para 133. That page 505, my lord.
Yes.
Yes. The second condition necessary for the valid application of clause B of the second proviso is that the disciplinary authority should record in writing its reasons for its satisfaction that it was not reasonably practicable to hold the inquiry contemplated under Article 311(2). This is, please mark my notes, this is a constitutional obligation. And if such reason is not recorded in writing, the order dispensing with the inquiry and the order of penalty following thereupon would both be void and unconstitutional. Then next parameters. It is obvious that the recording in writing of the reason for dispensing with the inquiry must precede the order imposing the penalty. The reason for dispensing with the inquiry, please mark, need not therefore find their place in the final order. It would be usual to record the reason separately and then consider the question of the penalty to be imposed and pass the order imposing the penalty. It would, however, be better to record the reason in the final order in order to avoid the allegation that the reason was not recorded in writing before passing with the final order, but was subsequently fabricated. So my court said it is better you disclose the reason. Then the reason for dispensing with the inquiry need not contain detailed particulars, but the reason must not be vague or just a repetition of the language of clause B of the second proviso. For instance, it would be no compliance with the requirement of clause B for the disciplinary authority simply to state that he was satisfied he was not reasonably practicable to hold any inquiry. Sometimes the situation may be such that it is not reasonably practicable to give detailed reasons for dispensing with the inquiry. This would, however, per se invalidate the order. Each case must be judged on its own merits in the light of its own fact. Please have 135 also. It was vehemently contended that if reasons are not recorded in the final order, they must be communicated to the concerned government servant to enable him to challenge the validity of the reasons in a departmental appeal or before a court of law, and that failure to communicate the reasons would invalidate the order. This contention too cannot be accepted. The constitutional requirement in clause B is that the reason for dispensing it with the inquiry should be recorded in writing. There is no obligation to communicate the reason to the government servant. As clause 3 of Article 311 makes the decision of the disciplinary authority on this final point, the question cannot be agitated in the departmental appeal, revision or review. This is clause 3 of Article 311. The obligation to record the reason in writing is provided in clause B so that the superiors of the disciplinary authority may be able to judge whether such authority has exercised its powers under clause B properly or not, with a view to judge the performance and capacity of that officer for the purposes of promotion, etc. It would be, however, be better for the disciplinary authority to communicate to the government servants its reasons for dispensing with the inquiry, because such communication would eliminate the possibility of the allegation being made that the reasons have been subsequently fabricated. It would enable the government servant to approach the High Court under Article 226, or in a fit case, this court under Article 32. If reasons are not communicated to the government servant and the matter comes to the court can direct the reasons to be produced and furnished to the government servant. And if still not produced, a presumption should be drawn that the reasons were not recorded in writing, and the imputed order would then stand invalidated. Such presumption can, however, be rebutted by satisfactory explanation by non-explanation. There is no mention, your lordships have seen, my lords, in the order itself, that they have dispensed with the inquiry under 311(2). So, my lords, this argument, my lords, whether it is without prejudice, with prejudice, my lords, is not available to them. My further submission is, my lords, that reason to dispense with, my lords, the inquiry is not a without, by the way, argument or a without prejudice argument, my lords. This decision, my lords, affects the officer because you have decided that you will not give him a hearing. So it cannot be made, my lords, by way of a without prejudice submission before this court. That without prejudice submission, your lordships have seen, has been subsequently clarified on facts, saying that in view of the police report and the damning allegations which were there, we thought it proper not to give them a hearing. Now, my lords, the learned single judge, my lords, has not considered this aspect of the matter, because if, my lords, they have dispensed with 311 inquiry, it's a different case, my lords. The case goes to a different pedestal. Your lordships will see in judicial review whether, my lords, the dispensation is called for, whether it is reasonably practicable not to hold an inquiry. Your lordships will see that, my lords, to the limited extent. Then the entire contours of the case changes. If they have dispensed with, then, my lords, I have no case on natural justice. I cannot come and tell your lordship that natural justice will have to be read into 19(2) because they have dispensed it on Article 311(2). Their case, my lords, is, my lords, they have played, my lords, I respectfully submit, ducks and drakes with the court. Their case, my lords, is one hand, 311(2) protection is not available to the appellant. That's the first case. Their case, my lords, was that 311(2) is not available. Argument was we were only probationers. Law is settled, my lordships have seen, my lords, the judgment Mr. K.N. Chaudhary is already placed, my lords, from Purushottam Lal Dhingra onwards, my lords, that even a probationary officer on probation, my lords, can have the benefit of 311(2). Then the second argument was that this is not stigmatic, this is not punitive. Because, my lords, decided cases have said, my lords, if the order is stigmatic, if it is punitive, then 311(2) protection is available to the officer. Now, my lords, the single judge, my lords, does not consider this 311(2) second proviso be whether, my lords, it was invoked, whether such an invocation was there, because the order says nothing. So with that, my lords, may I just pause here and take your lordships, my lords, straight to my lord Mohinder Singh Gill. True. I'm sure, my lord, your lordships have, my lord, even as a lawyer, one has gone through this. This is a magnum opus, my lords, of the Supreme Court. Even our Justice P.K. Goswami was part of this bench, man. Page 252, it starts. And I'm taking your lordships to page 264. To buttress my argument, my lords, that your lordships will read, my lords, the grounds for discharge as mentioned in the discharge order at page 259. 249. It cannot, my lords, be supplemented, my lords, later on by an officer to say what he meant by that order. Please come to running page 264, my lords. At the top, my lords, there are running pages. Paragraph 8, my lords. Paragraph 8, your lady said, running page 264. My lords has it? Yes. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise. Otherwise, an order bad in the beginning may by the time it comes to a court on account of a challenge get validated by additional grounds later brought out. we may here draw attention to the observations of Justice Vivian Bose's in Gordon Bhanji. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Please mark this next sentence. Public orders made by public authorities are meant to have public effect and are intended to effect the actings and conduct of those that are addressed and must be construed objectively with reference to the language used in the order itself. The orders are not like old wine, becoming better as they grow older. So they can't today bring in Article 311 2 proviso. Your lordships will peg them down to the order at page 249. And your lordships will test it, my lord. Does it say? Because another finding, my lord, by the single judge was, my lord, I will place that. Single judge said, my lord, there was extreme promptitude required, in view of which audio alteram partem rule was dispensed with. The single judge, there's a finding by the single judge that in view of the extreme promptitude and urgency, that petitioners could not, the appellants could not have continued in service. So because of which audio alteram partem rule was dispensed with. But I will make that good, my lords. What promptitude it was, my lords, when the FIR was filed, when she was arrested, when was the charge sheet filed, the material was already with the government. And after almost 7 months, my lords, what they do is they discharge the appellant. So my lords, there is no promptitude, but my respectful submission is, my lords, we'll read, my lords, your lordships will test the order on the basis of the language used in the order, my lords, and you will not be allowed them, my lords, to supplement it, what they meant by this order, including, my lords, invoking Article 311(2). Now, if your lordships just come, my lords, to my list of dates again, my lords. First page, if your lordships first come, let's just run through it, my lords, and then I'll make my submission. First, just page 1, my lords. Serial number 1. 30th June 16. Elizabeth, it's a yes. The appellant successfully appeared in the combined competitive examination in 2014 conducted by APSC, the results of which was declared on 30/6/16, and the appellant was selected. Name was recommended by APSC to the government of Assam for appointment. The appellant belongs to the 2014 batch of appointees, though the result was declared on 30th June 16. Prior to her selection in CCE 14, the appellant was working as an assistant branch manager in Hong Kong and Shanghai Banking Corporation, Guwahati, from 2010 to 16. On her being selected in CCE 14, the appellant resigned from the job as assistant manager HSBC Guwahati. Number 15/10/16. On the recommendation of the APSC, the appellant was appointed to the post of District Transport Officer, Government of Assam. Note, your lordship will come to note 3, my lords. Note 2. The recruitment and conditions of service of the appellant is governed by the Assam Transport Service Rules 2003. As per Rule 21(1) of the Assam Transport Service Rules, the probation period is 2 years, which quarter appellant was completed on 15/10/18. Rule 21(1) provides a member of the service shall be placed according to seniority on probation for a period of 2 years, provided that the period of probation may, for good and sufficient reasons, be extended by the governor in individual case for a specified period not exceeding a period of 2 years, provided that the period of probation may be curtailed or dispensed with in any case for good and sufficient reasons by the appointing authority. The probation period was never extended thereafter. Rather, the appellant was granted, please mark this one, 2 increments in terms of Rule 25 of the Assam Civil Service Rules, as there is no such provision under the Assam Transport Service Rules 2003. There is no provision for grant of increments to probationers. So we said she was granted increments, my lords, also. Now, Rule 25(1) of the Assam Service Rules provide increment. Rule 25(1) provides the first increment admissible to a member of the service in the junior grade timescale shall accrue on the expiry of 1 year from the date of his joining the service, but further increments due to shall be allowed only on his confirmation in the service. So the second increment which was given would have been given only to a person who is confirmed. Note 5, the appellant has received first and second increments. That is first from 31/10/16 to 6/12/16, and second from 14/3/18 to 15/3/18, and also on July 18 at rupees so and so. The fact remains that on completion of 2 years of satisfactory service as a probationer, a vested right accrued in the favor of the appellant to be considered for confirmation in the service. I'm not saying deemed confirmation because the rules don't say. So, I'm saying she has a vested right to be considered for confirmation. Now 27/10/16 is the Dibrugarh police station case was registered on a complaint made by Dr. Ansumita Gogoi alleging that one Nabakanta party demanded rupees 10 lakhs for recruiting the informant as dental surgeon. She further informed that Nabakanta party is running a network to carry out criminal activities to recruit people for different services in connivance with other unknown persons and request to take action as per law. There was no allegations against the appellant in the FIR or any allegations against the appellant services or a recruitment in transport service. However, the police on its own extended the scope of inquiry to 2013 and 14 batch as well. Then your lordship will skip 4 months on completion of her training. She was released. Then 13/1/10 office order attached to the district transport officers Kamrup. Then 30th November order attached to the transport department Assam secretary. Now please come to serial number 9 . On the left are the serial numbers for your lordship's convenience. 24/1/17. Dibrugarh police after investigation filed charge sheet number 3 before the learned special judge in Dibrugarh police station case number so and so against 10 accused, list of documents at so and so. Then 10 she was notification, she was transferred and posted as DTO Dibrugarh. Then please come 12, 18/7/18. Appellant was arrested in connection with said Dibrugarh PS case number 936/16. No suspension order was served on the appellant on account of being detained in custody for a period of more than 48 hours. Later on, the appellant obtained a suspension letter dated 24/7/18 from the department. The appellant remained in custody till she was granted bail by this honorable court on 11/10/2018. Then 10/9/18, the appellant wrote to the Commissioner and Secretary Department of Transport, Government of Assam for release of subsistence allowance as per the Assam Services Disciplinary and Appeal Rules. Then 14/9/18, this is important, madam. This is supplementary charge sheet number 6 was filed in Dibrugarh PS case number against 20 accused, including the appellant herein. The appellant has been arraigned as accused number 54 at page 107, and the charges and charged for the alleged offences under sections 12, 13, 2 of the PC Act, read with 109, 120B, 420, 465, 465, 468, 471, 420 IPC. Nevertheless, I pause here for a moment, madam. The lordship will just note here that she is not charged for the offence under section 8 of the Prevention of Corruption. Section 8, my lord, is bribery, bribing a public servant. The case set up, my lord, in the additional affidavit and which has swayed the learned single judge is that the appellant paid a bribe of 45 lakhs to procure her appointment. This is mentioned, my lord, in the additional affidavit at 4 places. Just have that, my lord. Something again very serious, my lord. I don't know how they can make such statements. Just have this, my lord, at page 277. My lord, has page 277. Please see, my lord, at the above para 42. The appellant paid rupees 45 lakhs for the appointment.
Just a moment.
Unless you make such allegations in an affidavit. You know, so you should see that, para 42.
Just a moment. Yes.
The losses will just see para 42. The writ petitioner has stated to have paid rupees 45 lakhs
Yes.
as bribe for securing the appointment in question. In addition to the accused, writ petitioners, one of the beneficiaries also made a statement before the learned competent court stating number of candidates who stood appointed pursuant to the recruitment process initiated by APSC has paid bribe for securing appointments to public office. Now, please see para 44, next page, Malaj. And all this, Malaj, is handed over in a sealed cover, Malaj. Just a para 44, Malaj.
Yes.
The statement, I'm reading Malaj, the second sentence. The statement of the said person, my lord, has that, have also been recorded before the learned competent court, which have been submitted before this honorable court in a sealed cover for its kind consideration. Before pursuant to the investigation been carried out, so far 10 charge sheets, my lords, have been filed before the concerned criminal court. Some of the said charges demonstrate the role of the accused persons, whose role has been unabated during the detailed and comprehensive investigation being carried out by the Assam police, are also been submitted in a sealed cover. So, my lords, the court took sealed cover documents on record and has rendered findings, my lords, in the impugned judgment based on these sealed cover records, which are not disclosed to us. So that's one attack of the single judge judgment is that reliance on sealed cover documents has, my lords, withered away my right under Article 226 and has denied me, my lords, a fair hearing before the learned single judge.
But at that time when it was presented, no
Objection was raised, my lords.
raised.
Yes. Even during the arguments, it was argued by Mr. Somnath Das. But my lords, the fact is this: today, my lords, you rely on sealed cover documents. You don't even, my lords, disclose the documents to us. You don't even give us inspection. And it is not their case, my lords, that it involves the security of the state, so we cannot disclose. They didn't take, my lords, the privilege under 123, 126 of the Indian Evidence Act. That's not pleaded. Their case is we are giving you in a sealed cover. And my lords, the latest decisions of the Supreme Court has deprecated such practices, saying that it denies a fair hearing to the litigant. Unless, my lords, there are national security issues where Official Secrets Act are involved, my lords, your lordships will then say no. The now Supreme Court has devised, my lords, that the amicus curiae can be appointed. Who will, my lords, inspect the records? A person of standing, my lords, in the court, who will be appointed, who will go through the records. But the courts have said if you rely on sealed cover records and documents, it denies a fair hearing to the litigant. And that is a ground good enough, my lords, to set aside the judgment. I'll place those decisions. Now, my lords, this is further reiterated, my lords, that this lady offered a bribe at, my lords.
But in the impugned order, I remember it's not there recorded. The
Finding?
objections. No objection raised. I did not notice it.
It's not noticed. But my lord, the records itself, so sealed cover documents was given.
No, seal cover is there, but objection.
And the court
when you say
records that I opened the documents which were furnished to me. I went through the records and
Yes.
based on which findings are given. Now, my lords, this contention, my lord, is reiterated, my lords, at page 287 also.
In the memo appeal, have you taken a ground to that effect that objection was raised? Because you can address this later.
I will address that. I understand what your lordship is saying, my lord. Just have page 287, my lord. Because that's one of my, my lords, one of my principal ground, my lords, that this judgment of the single judge, my lords, in any view of the matter needs to be set aside. Because it relies on seal cover records. And my lord, there are numerous places where the single judge, obviously, my lord, if the if the state is saying that there is a confession by my client, the appellant, of paying a 45 lakh bribe, obviously the judge will proceed. What the honorable judge says, my lords, is no citation has been given to me to show that I cannot rely on police records. My lords, Section 25 of the Indian Evidence Act says it bars, my lords, a confession recorded by the police. Your lordship knows, my lords, if police is allowed to record confessions, my lords, they can record anything, my lords, when I'm in custody. That's why, my lords, the protection under Section 25 says confessions to a police officer not to be proved. 26 says, my lords, confession by accused while in custody of police not to be proved. Yet, my lords, the single judge says that no citation was placed before me to show that, which shows that a judge cannot, a court of law cannot go into police records. Now, my lords, one other aspect, my lords, and this when a lordship is considering this, 161 statements of witnesses are considered by the single judge. Section 162 bars it, my lords. There's a bar, my lords, under Section 162 that otherwise, my lords, what is the prosecution going to do? All they have to do is, with the 161 statements, my lords, they'll prove the case. Courts have said, no, you have to summon those witnesses. If they resile from their 161 statement, you can confront him with the 161. That's the limited purpose of 161, my lords. The lordship knows that, my lords, both your lordships have tremendous experience, my lords, on the trial side.
Not tremendous, a little bit.
No, my lords, tremendous. We know that, my lords. In fact, I know it for a matter of fact. Both your lords. So, my lords, on the fundamentals of law, my lords, what judgment am I required to place before the court, my lords? The statute bars it. And, my lords, Tehsildar Singh's judgment, 1952 Supreme Court says that 161 statement cannot be looked into. It means nothing. The Tehsildar Singh's judgment, my lords, I will place it, my lord, when is 1959 Supreme Court 1012. It's a famous, my lords, judgment on 161 statements and 162, my lords. That 161 statements, my lords, has no validity, nothing. So unless that witness, my lords, comes into the witness box, and only limited purpose, my lords, under 162 is that if he resiles from his statement, my lords, he can be confronted with that 161 statement. Only that's the limited purpose, my lords. Just no statement made by a person to a police officer in the course of investigation under this chapter shall, if reduced in writing, be signed by the person making it, nor shall any such statement or any record thereof, whether in a police diary or otherwise, or any part of such statement or record, be used for any other purpose, save as hereinafter provided at any inquiry or trial in respect of the offense under the investigation at the time when such statements were made. Provided that when the witness is called for prosecution for the prosecution in such inquiry or trial, whose statements have been reduced in writing as aforesaid, any part of his statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witness in the manner provided in Section 155 of the Indian Evidence Act. And when any part of such statement is so used, any part thereof may also be used in re-examination of such witness, but for the purpose only of explaining any matter referred to in this cross-examination. So, my lords, 161 statement by its very nature, my lords, is inadmissible, except for the limited purpose, my lords, of confronting the witness when he comes into the witness box. But, my lords, with respect, my lords, 161 statements placed by the state in a seal cover has been looked into by the court. My lords, if there is, my lords, an allegation that I attempted even to bribe, it's not a case of attempt. There are cases I have bribed to secure my appointment. Because the offense under Section 8 of the Prevention of Corruption Act should have been added, my lords, in that charge sheet. And in the charge sheet, my lords, there is no allegation at all. The charge sheet is, yeah, I can read out, my lords, but there is not even a whisper of an allegation that any person was bribed, that the appellant bribed any person to enter the services.
Is the charge sheet number 4 available?
6.
Yours was 6 or 4?
6. I'm in charge sheet number 6, my lord. Okay, that's part of the record itself, my lord. Just have my lord's page here. 99 to 151.
Page number?
99 minutes.
99. Because once we are there, we'll just look into it.
Just mark the page, my lord. At page 107, I am accused number 54. Suranjita Hajarika at the top, my lords.
Yes.
And the allegation square, my lords, the accused number 54 is at para 16.9 at page 129, 130. That's the only allegation. Paragraph 16.9 at pages 129 to 130. Your lordships may take it, my lords.
No, it's
There is-
okay.
There is not even a whisper of any such bribe being offered to any officer to secure an appointment.
Mr. Chaudhary, we are not doubting you, but
no,
unless we look
no,
at the
no, no,
document,
but the
we
record,
won't
my lords-
have,
no, but
we
I'm
won't
also-
have retaining
No.
capacity.
So I'm duty bound, my lords, to place it, my lords.
107 and thereafter page 120.
129, my lords, paragraph 16.9, 129, 130. That's the only allegation. It's part of paragraph 16.9, A, B, C, D. Till E, till D, my lords. It goes to 130, 129, 130.
Yes.
No, my lords, this, my lords, action of the state respondents in, my lords, irresponsibly stating that I have made a offer of bribe of 45 lakhs. I had paid, my lord, not an offer. I am not prosecuted for the offense under section 8. This is not, the allegation is not there against me. Now, my lords, please see what the single judge does, my lords. We don't know, my lords, where are those confessional statements? Now I'm appearing before the trial court, my lords. 207 CRPC compliance has been done. The records have been given to me. There is no such confessional statement at all. Assuming, my lord, there is a confessional statement, my lords, it is barred by section 25 and 26 when I'm in custody. When the accused is in custody and police is recording confessions. Now, please have, my lord, page 452. How, my lord, the single judge got swayed, my lord, with this. Obviously, my lord, it's a very serious allegation. Who I have paid? Somebody has to be paid, my lord, and there is no allegation in the charge sheet. That is why, my lord, my respectful submission is, my lord, the court should not, my lord, have looked into police records, taken it as a gospel truth, my lord. When investigation was ongoing, further investigation is going on, my lord. And whatever is has to be proved will be proved during the trial. Now, please have page 452.
452.
452. I will read para 44 from page 452, my lord. The ladies has page 452.
Yes, we are there.
Paragraph 44 at the foot of the page, Manoj. Without entering into any legal argument as to its admissibility, which is for the appropriate fora to decide. Manoj, obviously, if you're not getting into appropriate fora is the criminal court which will decide. Manoj. The office files also contain statements, please mark, my lords, made by a section of the petitioners before the police admitting to their complicity in the illegal activity to which they were benefited. This is hit by section 25, 26 of the Evidence Act. It says, my lords, made by a section of the petitioners before the police admitting to their complicity in the illegal activity to which they were beneficiaries. The statement of such petitioners found in the office files are that of, please turn the page, my lords. I am Suranjita Hajarika, 854. Lordships have seen this much, Suranjita Hajarika. Then the next line, my lords. The statements are basically with regard to their appearance in APSC main examination and making payment of money ranging between 25 to 40 lakhs to Sri Rakesh Kumar Paul through his agents for getting selection to APSC. Well, just pause here for a moment. Your lordships have already seen, my lord, that para 42, the amount was 45 lakhs. Single judge says, my lord, it ranges between 25 to 40 lakhs. From 45, my lord, it's come to 40. My lord. That's the problem, my lord, when you rely upon police can record anything, my lord. And that's why the safeguards under the Indian Evidence Act, that the confession of an accused, if recorded when in police custody, is inadmissible. And we don't know, my lord, because these records were not disclosed to me. The Honorable Judge, my lord, has rendered findings. I'm reading again, my lord. The statements are basically with regard to their appearance in APSC main examination and making payment of money ranging between 25 to 40 lakhs to Rakesh Kumar Paul through his agents for getting selection by the APSC and for securing jobs. The office files as indicated above, but these office files are not disclosed. Chronologically records the events taking place following information received from Dibrugarh police as regards arrest of the petitioner in connection with Dibrugarh PS case number so-and-so. From the decision calling for detailed reports from the Dibrugarh police for taking further action to receiving such reports in connection with the arrest of the petitioners, to the decision to withdraw the services of the petitioners pending action to be taken by the personnel department, government of Assam, to obtaining the views of the judicial department before taking final decision, and to obtain the approval accorded by the Chief Minister of Assam, together with the views of the Advocate General Assam, before the petitioners were discharged from service by orders of the Governor of Assam. The same fines recorded in the respective office files. I'm sorry, I'm unable to assist your lordships because we don't know what these office files were. Seal cover. Clearly, please mark, the allegations of irregularities on the part of the petitioners are not allegations of any irregularities, negligence, inefficiency, and misconduct taking place during discharge of their duties post-recruitment or after having appointment to public office. The allegations against the petitioners in indulging in gross irregularities and fraud, please mark, my lords, involving payment of illegal gratification. A single judge got carried away, my lords, by this. that illegal gratification was paid involving payment of illegal gratification for securing appointments to public offices are apparently of pre-recruitment period, that is before they were appointed in public offices. In the understanding of this court, the element of misconduct which reverberates in the submissions made on behalf of the petitioners is attributable only in respect of a period subsequent to valid initial appointment. Please mark again, not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during the recruitment process and or before appointment have been made or before a person is born into the cadre service would constitute misconduct. Firstly, my lords, Article 311 does not talk of misconduct. It says moment you reduce in rank, you remove or you discharge. And 311 says charges will have to be made known to the officer concerned. Secondly, my lords, there is no such distinction in law between pre-recruitment and post-recruitment. That's my respectful submission, my lord. I'll make it good. That there is no such distinction, my lords, in law between pre-recruitment anomalies and post-recruitment anomalies. And my lords, moment an officer enters the service, he gets the constitutional protection under Article 311. Now, law is also settled, even probationers are entitled to. So, moment you enter into the service, you are entitled to that protection. And if you want to deny that protection, my lords, the only way you can deny that protection, my lords, is under 311 second proviso, subclause B, that it is not reasonably practicable to hold the inquiry. Now, my lords, now not a single citation has been placed, my lords. My learned friend, Mr. N.N.B. Chaudhary, my lords, placed before your lordship Ratnesh Kumar Chaudhary's case, that chest physiotherapist case, lordships recall, my lords. That was a case, my lords, of pre-recruitment anomalies. Bina Pani De, my lords, that classic judgment of 67 is a pre-recruitment anomaly because she joined as a doctor understating her age. That was the allegation, that her age which certificate which she has given of her age was wrong. Because of which, my lords, she was retired prematurely, saying that you've already reached the superannuation stage. When she came to the Supreme Court said, no, you have to give her a hearing. So that's how, my lord, that's where it said, my lord, even administrative orders which impacts on the citizen, my lord, principles of natural justice will have to be followed. Now, my lord, please turn over the page, my lord. Then, my lords, then the court says a vain attempt was made when reliance was placed on para 37 of Palak Modi. Well, Palak Modi was a case, my lords, where the probationers, prior to their confirmation, took a test. In that test, my lord, there was some anomalies. So Justice Bhuya says that you made a vain attempt, but that was after Palak Modi had entered the services as a probationer, and while confirming that examination which he gave, it was there that there were anomalies. So it says that it is not a pre-recruitment anomaly in that sense. I mean, just read that last 4 lines of this paragraph, my lord. As misconduct cannot be pre-recruitment phenomena. The lordship has that, my lord. This is a finding, my lord, in my respectful submission, my lord, not borne out from law. I will make it good. As misconduct cannot be a pre-recruitment phenomena, the very bedrock of the submissions made on behalf of the petitioners, that the impugned action been founded on misconduct, therefore the principles of natural justice, or the provisions of 311 could not have been dispensed with in the considered of the opinion of the court, does not hold water. Now, let's, this finding also, my lord, if a lordship sees, my lord, it says, therefore, the principles of natural justice. So, my lord, the argument on principles of natural justice is Dehor's Article 311. The case is, my lords, that moment you discharge, it prejudicially affects me. It's an order which has civil consequences against me. So even if there is no provision, I am reading this in the context of Article Section 19, Rule 19.2. That in Rule 19.2, your lordships will real principles of natural justice because there is no such provision. There is no bar either. So your lordships will read it because this order has consequences against the officer. So that's, my lords, a separate compartment. And the argument on Article 311 is a different compartment. That an officer, my lords, nonetheless has a constitutional protection under Article 311 too, that if you reduce the officer in rank or you dismiss or discharge him, you have to conduct an inquiry. But the court, my lords, mixes up both the two and says that therefore the principles of natural justice and the provisions of Article 311 could not have been dispensed with in the considered opinion of the court does not hold any water. Please now turn across the page at page 455. I am on, my lords, the allegation that I bribed, my lords, and bribed somebody to enter the services. Lordships will read, my lords, around 7 lines from the top. They are 52 writ petitioners. Your lordships has that?
Yes.
They are 52 writ petitioners herein and another 8 candidates who are not before the court. Allegations are with regard to criminal conspiracies resulting in tampering with the examination process for the benefit of the petitioners herein. Investigations have revealed that the petitioners had indulged in unfair means for getting selected by paying bribe. Once again, my lords, on extraneous considerations, but certainly not on account of merit. There are cogent materials on which the respondent authority derived satisfaction that the selection process through which the petitioner came to be selected and eventually appointed was tainted by fraud. Irregularities in the selection and appointment of the petitioner has been found at the threshold itself. Can it be said that the state action was not bona fide in discharging the petitioners from service, and was it not the solemn duty of the state to take impugned action for maintaining sanctity and reposing faith in the system and public officers in relation to the affairs of the state government? Can it be said that it was not open to the state government to act on disturbing revelations emanating from the police investigations with regard to grave illegalities being discovered involving the petitioners during the selection process, which illegalities occurred well before they entered into the service? To reiterate, the discharge of the petitioners from service was not on account of any alleged misconduct after appointment, but on discovery of fraud at the point of their entry into service. There is a clear dividing line between the challenge made to an order of discharge on grounds of misconduct during, again, my lords, pre- and post-recruitment period, and a challenge made to an order of discharge on the ground of irregularity and illegalities finding place relatable to a pre-recruitment period, whereas the former would invariably invite compliance, please mark, my lords, of odi alteram partem rule of natural justice and of compliance with the protection of Article 311 of the Constitution. The latter can fall within the category of exceptions to the rule of natural justice, rule of odi alteram partem, particularly if there are reliable materials to reach the satisfaction insofar as the petitioners are concerned. The examination process and the selection was vitiated. Going back to Parasuttam Lal Dhingra and some saying it is only when termination is seen to be founded on manifest misconduct, it could be a punishment when you go to violate Article 311. In the absence of an inquiry, however, as observed above, arguments of misconduct being the foundation are wholly misplaced, misconceived, inasmuch as discharge of the petitioners are not founded on the phenomena of misconduct, as is understood in service jurisprudence. So, the court says, my lords, that odi alteram partem rule, my lords, cannot be here, my lords. There was no requirement to give a hearing. And even the guarantees under Article 311 was not available. Why, my lords? Because these are pre-recruitment anomalies. My respectful submission is, my lords, Article 311 does not make any such compartment. Moment as an officer you enter the service, the Constitution provides me the protection. There is no such compartmentalization, my lords, within Article 311. This compartmentalization, in my respectful submission, my lords, has no legal sanctity, my lords. It has no constitutional sanctity because the protection, my lord, is to the officer concerned. How you entered the service is immaterial. Moment you are on the roll as a civil servant, my lords, the protection under 311 is available. In fact, that's how my lords, Article 311 opens.
What is mine?
No person who is a member of a civil service of the union or an all India service or a civil service of a state or holds a civil post under a union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. And two, no such person as aforesaid, moment I'm in the role, shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity to be heard in respect of those charges. So, my respectful submission is, Article 311(2) does not, support this compartmentalize. Article 311 protection is available to every officer moment he enters the service. Even probationary officers, law has now been settled that it is not only for permanent employees, even for probationers, 311 protection is there. And that protection, cannot be denied on the ground that there were pre-recruitment anomalies. I come back, now to the list of dates again, Serial number 14, page 3. Supplementary charge sheet number 6 bin 3 of 2007 was filed in Dibrugarh PS case number 936 against 20 accused, including the appellant herein. The appellant has been arraigned as accused number 54 at page 107 and charged for the alleged offences under sections 12, 13, 2 of the PC Act, read with sections 109, 120B, 420, 465, 468, 471, 201 IPC. The allegations against the appellant in the supplementary charge sheet number, it should be 6, I'm sorry, is at para 3. That's a typo, instead of 3, it should be 6. Note 2, there is no mention in the charge sheet by the investigating agency of the petitioner having made any alleged disclosure / confession before the police. There is no allegations against the appellant of having offered or paid any bribe to any person. So the offense under section 8 is not there. It is missing, from the charge sheet. And if you just turn over the page, 15 is, when he was granted bail by the High Court, 16 is, when a 2-year period came to an end, her probation. Then, just have 18, that fact which I had stated in the opening, the appellant, after expiry of 60 days from 1/1/18, filed a writ petition before the learned single judge of this honorable court, internally assailing the illegal actions of the respondent and seeking a declaration that the appellant is a permanent member of the service. The learned single judge of this honorable court issued notice, and while taking note of the apprehension that the petitioner may be discharged from service, observed that it goes without saying that the authority will have to abide by the law before discharging any person from service, and subsistence allowance, if not paid, shall be released to the appellant along with arrears. The said order dated 11/1/19 was communicated by the counsel for the appellant to the department by letter of 14/1/19. Then, 21/1/19, the appellant was arbitrarily and illegally discharged from service in purported exercise of power under Rules 19 and 19(2) of the Assam Transport Service Rules 2003 with immediate effect. But I have quoted Rule 19. I'll skip that. Note 2. No notice, much less any opportunity of hearing, was provided to the appellant before issuing the discharge order. It was the contention of the state before the single judge. Please mark, that Rule 19 does not mandate compliance with the principles of natural justice before exercising the power of discharge. This, your lordship, will find at page 257, Their stand was that Rule 19, just have 257. So that's one core issue which the lordships will have to consider. And if I am successful in convincing your lordships that Rule 19(2) itself visualizes the principle hearing, I am through, 257. My lords, has page 257. Around 8 lines from the top, it is submitted that. My lords, has that? Your ladies, sir? Yeah, it is submitted that Rule 19 of the 2003 rules does not mandate compliance of principles of natural justice before exercising the power of discharge. Even otherwise, in the facts of the case, there cannot be any requirement of any pre or post decisional hearing while exercising the power of discharge from service, inasmuch as such power of discharge is exercised without ascertaining the culpability or guilt of the petitioner or the concerned officer. The order at 249 speaks otherwise, that I am accused in a corruption case. The state respondents only verified the information received on the basis of materials disclosed by the Dibrugarh police, but did not arrive at any finding in respect of culpability of the petitioner. Moreover, the facts of the circumstance present case, the state respondents had no desire to carry out any formal departmental inquiry. That they had no desire contradicts their without prejudice argument. They had no desire to conduct any formal departmental inquiry. Moreover, in the facts and circumstances of the case, the state respondents had no desire to carry out any formal departmental inquiry. On the facts of the case, it was only deemed fit and proper to exercise the power of discharge simpliciter without stigmatizing the petitioner. The exercise of power of discharge from service under Rule 19 is not dependent upon continuation or otherwise of a criminal proceedings or its existence. The lordships have read the order, my lord. The order extensively quotes about the Dibrugarh police station case, my lord. It talks about, my lord, some forensic report. And then it says, my lord, it has no connection with the continuance of the Dibrugarh PS case. If, my lord, this is the stand of the state, how could they, my lord, rely upon seal cover records of investigation before the single judge? I'm reading again, my lord. The exercise of power of discharge under Rule 19 is not dependent upon continuation or otherwise of a criminal proceedings or its existence. It may be stated that the petitioner was placed under suspension under 6(2) of the Assam Disciplinary Service Rule after being arrested and detained for more than 48 hours. In the facts and circumstances of the case, in view of the nature of the discharge order, Honorable Court may be pleased not to extend the stay, because there was a stay, my lord, but Justice Koteshwar Singh, I'll place that order. That order, my lords, your lordships will find at page 355. What they say here is that we had no desire to conduct the departmental proceedings. B, the criminal case has no consequence, and the continuance of the criminal case will have no consequence on the petitioner, insofar as this order is concerned under Rule 19. And yet, my lords, in the additional affidavit and before the single judge, my lords, seal cover records are produced, and the seal cover records are the only basis on the basis of which, my lord, the state argued that we have segregated the tainted from the untainted. That's their case, my lord. And the single judge says that the probe has been thorough. It meets my satisfaction. So if the probe is thorough, my lord, firstly, my lord, my respectful submission is it was not within the ambit of the single judge, my lords. With regard to, my lords, whether the probe in Dibrugarh PS case, my lords, is going on properly. It was not within the domain. And, my lords, the findings which the honorable single judge has rendered, my lords, in the judgment, in my respectful submission, is going to prejudice the appellant and all other accused, my lords, who have been charged before the trial court. There cannot be any discharge, because the High Court has already given a stamp of approval on the investigation, saying that it meets our satisfaction. The probe has been thorough. It has been fair, which, my lords, in my respectful submission, was not within the ambit of the court. What the court was looking into was, my lords, the validity of the discharge orders. It was a civil writ petition. The learned single judge, my lords, ought not to have made observations or findings, my lords, on the nature of the probe, on whether it is fair or unfair. And these findings, my lords, is going to, my lords, create huge difficulties, my lords, in the trial court. If I was for the prosecutor, my lords, I will place this judgment before the court and say that these findings are binding on you. Where is the question of a discharge here? You proceed with the trial. One prayer I'm going to make, my lords, is your lordship will have to expunge these remarks, my lords, of the single judge made, my lords, with regard to the probe, which is the subject matter of special case number 2 of 17. It's going to have, my lords, tremendous impact, my lords, against the accused persons, including the appellant hearing. And the learned single judge, with due respect, my lords, ought not to have commented, my lords, on the veracity of the criminal investigation or on the nature of the probe. And these findings, my lords, are beyond the ambit of the jurisdiction of the single judge. and if allowed to stand, my lords, would cause manifest injustice, my lords, to each and every accused who is facing trial there. Because, my lords, he has commented, my lord, the honorable single judge has commented, my lords, on the veracity of the probe, which formed the subject matter of charge sheet number 66. Now, my lords, I come back, my lords, to page 5 of my list of dates. Note 4. My lords, the notes are my submissions, my lords. Alongside it, I'm making my submissions also, my lords. At page 5, my lords, note 4. The appellant contends that there were no unsatisfactory reports on her service during her probationary period as per Rule 19.1. And also there was no violation of Rule 19.2 as the appellant was duly qualified for appointment in terms of Rule 7, 8, 9, and 10 of the Assam Transport Service Rules. The appellant contends that the appellant's discharge order on a bare reading is stigmatic and punitive in nature without following the principles of natural justice and makes her future employment in any field an impossibility. Then 6, my lord, the discharge order does not record any satisfaction in writing that it is not reasonably practicable to hold such inquiry as envisaged under 11.2 of the second proviso. My lord, I pause here for a moment, my lord. Take your lordships back to the single judge order, my lord. Just have page 419, my lord, paragraph 5.3. Page 419. The foot of the page, my lord, is the appellant, my lord, whom I represent, her discharge order. It goes on till page 2420, my lord. The entire discharge order is extracted in the single judge's order. And no finding, no observation, there is no finding by the learned single judge on this discharge order. The seat anchor of my case was that moment you read the discharge order on the plain reading is stigmatic and punitive. I had, my lords, lordships recall, my lords, I had compared this with page 205, where, my lords, discharge orders are there, which are 3-line orders, which I said they may be innocuous orders, and the law is, my lords, then your lordships will lift the veil and go behind the orders as to what exactly weighed with the authority. In my case, my lords, we don't even need to lift the veil. The order itself is stigmatic. It is not that, my lord, the learned single judge overlooked the discharge order. This is extracted, my lord, with 419420, and there is no finding, no observation by the learned single judge on my discharge order. And this, my lords, in my respectful submission, is an error apparent on the face of the judgment. My case was this, my lords. So amongst all discharge orders, my lords, the honorable judge extracted, my lord, 3, because there were actually 3 separate samples, and picked up my discharge order. Now, when your lordships has that file, my lord, please come to page 355.
No, but you'll have to expand, because what has happened is that the learned single judge, they have, the learned single judge has approved the discharge.
Yes.
So obviously it is approving this.
No, but my argument was on the wordings of the order. Look at the order itself. On the face of it, it is stigmatic, it is punitive. There is no such finding. That's my objection, my lord, that the court should have at least said that I have read this order. It is not punitive. It is not stigmatic. And my lord, now please have, my lord, Justice Koteswar Singh's order, my lord, 355 at 356, my lord. And I'll commend your lordships, my lords, to approve, my lord, in fact, this interim order, my lords. It analyzes, my lords, Rule 19. 356, my lords. Paragraph 3. The learned counsel for the petitioner submits that this case in similar case has passed the order by which similar discharge orders have been suspended by the court. He submits that the applicant petitioner is similarly situated as the petitioners in the opposite cases. It has been submitted that even if the authorities treat the applicant petitioner to be on probation, law provides that while discharging a probationer, the same can be done in terms of appointment order and also for unsatisfactory service. However, if the discharge order is stigmatic in nature, it must be proceeded by an inquiry. Please have para 5, the stand of the state. Learned counsel for the state, however, submits that this narration of facts would indicate that the service of the petitioner is not at all satisfactory, and it is in that background that the petitioner applicant has been discharged. So, the case was 19-1. It was unsatisfactory, so they have been discharged. Now, please turn over the page, madam. And madam, in my respectful submission, I'll comment for your lordship for acceptance, madam. The reasoning, madam, in the interim order, madam, is in line with the settled position in law. A reading of the impugned discharge order indicates that it is stigmatic in nature, as serious allegations have been made against the petitioner, which was the basis for discharge of the petitioner. Since it has been admitted by the learned counsel for the respondent that it was not preceded by an inquiry, though a criminal case has been pending and charge sheet has been filed, this court is of the prima facie view that the discharge order is not sustainable in law. Accordingly, the impugned discharge order dated 21/1/19 will remain suspended till the next returnable date, on which date the learned counsel for the respondent will file a detailed affidavit, on which the further continuation of interim order will be considered. If the applicant has not been paid subsistence allowance for the period when the petitioner was under suspension as claimed, the same may be released at the earliest. So, the court state the discharge order, and this is an extraordinary order, because the court saw on a bare reading of the order itself that it is stigmatic. It is punitive. It refers to a criminal case. And most respectfully, I will commend your lordships, to endorse, the view taken, in the interim order, that the discharge order on the face of it is stigmatic for the appellant, hearing. Now your lordships will come to skip the other part. Come to page 7, minutes. Serial number 24, minutes. The writ petitions were listed before the learned single judge. Your ladyship has page 7.
Yes, we have.
I'm grateful. The writ petitions were listed before the learned single judge when the learned senior counsel appearing for the state respondent requested for an opportunity to file relevant documents by way of affidavit in some of these petitions, as affidavit in opposition could not be filed in all writ petitions. This order, Mr. Divanta Das had placed before your lordships. Then July 19, the state respondents filed an additional affidavit in opposition in WPC number so-and-so before the learned single judge of this Honorable High Court. No leave was applied for or granted by the learned single judge to file the said additional affidavit in opposition. Along with the said affidavit in opposition, the state respondent submitted and placed on record, please mark, in a seal cover, materials which was not disclosed to the petitioners therein. See paragraphs 44 and 45 at page 278 and paragraph 66 at page 287, which I just read out from the additional affidavit. The learned single judge has relied upon the materials given in the seal cover, thereby making the process of adjudication vague and opaque. And the learned single judge has proceeded to decide the writ petitions and render findings by extensively relying upon the unsaid materials provided in seal covers. The stand of the respondents as recorded in the additional affidavit was a substantial and remarkable improvement over the stand taken in the first affidavit in opposition. I'm saying it is a tectonic shift. They suddenly take a stand which was not there in the earlier affidavit. Your lordships will see whether your lordships will allow such contradictory stands to be taken without withdrawing the earlier affidavit. It was further contended that the discharge order is not in the nature of punishment, as the petitioner was serving as a probationary period and found to be unfit for public service by the employer. The discharge order, your lordship does not say this. The additional affidavit in opposition makes reckless allegations against the appellant of her having confessed to have paid a bribe of rupees 45 lakhs for securing the appointment in question. I have placed those paragraphs, madam. It is further contended in para 7 at page 264 that the petitioners had paid huge amount of illegal gratification to other accused persons, including Sri Rakesh Kumar Paul. The said allegation has been reiterated in paragraph 8 at page 264, para 14 at page 266, and para 38 at page 276, that the petitioners have secured appointments to public offices by paying illegal gratification. This allegation is outlandish, false, and false to the knowledge of the deponent. There is no such alleged disclosure/confession filed with the charge sheet, nor is there even a whisper of an allegation against the appellant of having paid any bribe to any person in the supplementary charge sheet number 6 or in any of the supplementary charge sheets filed thereafter. In para 22, page 269, the state respondent stated that all the writ petitions in the present batch of writ petitions had stood identified as the beneficiaries of this colossal fraud in securing the appointment to public offices by illegal means. As an imperative corrective measure, they were discharged from office. Then note 5, the state respondents further stated that a discharge order is a simpliciter discharge order and there is no element of any stigma attached to it. The discharge order is not in the nature of punishment, as the petitioner was serving on probationary period and found to be unsafe for public service by the employer, i.e. the answering respondent. In the said additional affidavit, the state respondents for the first time disclosed, madam, please mark this, madam, this is something, madam, which will have a bearing, that a preliminary inquiry was conducted, including investigation carried out by the police in the present case prior to issuing the order of discharge. Please have page 286, madam, because this has not been disclosed anywhere else, madam. And this is what happens, madam, when you try and disclose more, something you will give out. Paragraph 64, madam. It is most respectfully submitted, my lord, your ladyship, madam, at page 286. It is most respectfully submitted that it is always open to the state as an employer. Please mark, to have regard to any preliminary inquiry, including the investigation carried out by the police in the present case. So I am completely at the dark. Even in this preliminary inquiry, my lords, I was not involved. And this is disclosed for the first time in the additional affidavit filed in July 19. And this is, my lords, reiterated, if your lordships will just mark it here, my lords, at paragraph 77, page 293. Because there are, my lords, decided cases which say that if you hold a preliminary inquiry behind the back of the employee, you have to give a hearing. So it is not a simplicity discharge order, my lords. The third line from page 293, it is reiterated that discharge order dated 21/1/19 is entirely in conformity with law. It is denied petitioner is deemed to be confirmed in his service. It is denied that the said discharge order cast or attaches any stigma. It is most respectfully reiterated. It is always open to the state as an employer to have regard to any preliminary inquiry, including the investigation carried out by the police in the present case. Such material would form the motive for discharge of the petitioner from service and not the foundation thereof. And as such, the discharge order cannot be said to be stigmatic in nature. I was, my lords, at page 8, my lords, of my list of dates. Note 6, my lords, where I refer to your lordships to the preliminary inquiry, my lords, which was conducted as mentioned, my lords, in paragraph 64 and paragraph 77. And this preliminary inquiry, my lords, I got to know only in the additional affidavit. I was not involved, my lords, in any such inquiry. Everything was done ex parte, my lords. I was not given any opportunity of hearing. Now, my lords, note 7, if your lordship said, I already made my submissions on that, my lords. Not reasonably practicable, my lords. That part I have done. Please come to, my lords, page 9. Tulsiram Patel, I have already referred to. Note 8. It was the contention of the state respondents as stated in para 59 at page 285 that whenever the competent authority is satisfied that the conduct of a government servant during probationary period is not satisfactory or his/her continuance in service is not in public interest because of his/her misconduct, unsuitability, integrity, etc., such employees can be discharged from service and such employees are not afforded the protection under Article 311 of the Constitution. Then clause note 9, Manali has got the Tulsiram Patel. Those paragraphs your lordship have already marked, 133 to 135. Paragraph 133 at page 505, 133, 134, and 135 minutes. Now, note 9. Though it was the case of the state respondents that the writ petitioners obtained their appointments in a fraudulent and corrupted selection process carried out by the Assam Public Service Commission. But please mark, they have used the words fraudulent and corrupted selection process. It is not their case, my lords, that the entire process is vitiated. What they have done, my lords, is through the police investigation. They are saying that these set of writ petitioners are the tainted ones. There is no, my lords, no segregation done, my lords, except the police investigation. Unlike, my lords, in Joginder Pal Singh's case, Inder Pal Singh Kalon's case, and even the state of West Bengal, the latest judgment, my lords, teacher's appointment, there was a committee set up of retired judges who, my lords, carried out this exercise and then pointed out that the entire process is fraudulent, so you cancel the entire process en masse. Yeah, my lords, nobody has, there is no neutral authority or no authority has done it. They are saying police investigation. Police investigation, Mr. Devanta Das, my lords, was laying pains to explain that the police investigation, my lords, was a tainted investigation. The fact that, my lords, pursuant to the orders of this court on 30th September 2023, a special investigation team is, my lords, was constituted, removing the earlier investigating officer. Earlier investigating officer was a gentleman called Panesar. Now in the special investigation team, my lords, the investigating officer is one Pratik Thove. He's an IPS officer. And this Pratik Thove was thereafter removed by the special judge by an order of 24/6/2024. And my lords, Mr. Kalita, Upen Kalita, DSP, was appointed as an investigating officer who in turn filed charge sheet number 14. So, my lords, all this speaks volumes of the investigation. So today, my lords, you can't on a tentative, on some material, my lords, which is tentative. The police investigation says so. Police investigation has, my lords, in view of police investigation, these writ petitioners are a lot of 52 who are tainted. In fact, my lords, there are 3 approvers. Those approvers, my lords, against them, they are in service. How can you, an approver, one can understand, is given pardon by the court. That's for the criminal case. But you cannot allow, my lords, if the approver is also similarly placed like others, that person's entry also, my lords, is with fraud, which they are saying, my lords, colossal fraud, which they are saying, then those approvers cannot continue in service, my lords. You can pardon the approver, my lords, for the purposes of the trial. That is for the criminal case. Under 307, my lords, pardon is given, my lords, 306, my lords, tender of pardon to an accomplice. So, my lords, an accomplice is equally guilty. Only thing is given pardon for the purposes of the trial. But that approver, my lords, there are 3 approvers who are still continuing in service, my lords, against them no action has been taken. So if my lords, from the standpoint of the state, I am, my lords, in a position to point out that the entire thing has been pick and choose. That they have picked up a few officers whom they felt were inconvenient to them. You discharge them immediately. There are a certain lot, my lords, who are still continuing in service. It is, though they are using words like colossal fraud, fraudulent, corrupted selection process. The selection process, my lords, has not been cancelled. Unlike, my lords, the Punjab PPSC case, my lords. Unlike, my lords, the state of West Bengal recent judgment, where, my lords, the process, my lords, Mr. Diganta Das, my lords, placed a 3-pronged test, my lords, of Joginder Pal Singh. This is not done. That exercise is not done in the present case. So I don't need to go that far, my lords. My submission is, my lords, that on the basis of a police report, a police investigation which is merely tentative, till, my lords, it is proved in a court of law, you cannot rely on that police report as gospel truth and take action, my lords, against the officers. Very well, I understand, my lordship. May I request for something, my lords? Sorry, my lords?
Since you have already given the note of argument,
Yes, ma'am.
we'll take it on record along with the citations.
Yes, ma'am.
Anything which is left out can be supplemented during the closure argument later on.
I want to just place a few judgments, my lords.
You can
To make
mark
good
it
my,
and
make good my submission, my
you
lord.
can mark it and give it to us because we are running very short of time. That's why, because unless we
Or-
manage our time.
Or if your lordships give me 1 hour more. So,
No, because in the closing argument also, after the state makes the argument, you'll also be making that, you can add those there.
give me, my lords, to close, I'll just take half an hour, my lords.
Okay, then tomorrow then.
Tomorrow, Lordship, we will remind Lordship at 2, although Lordship today started at 2. Also, Lordship, sorry to others, but just for idea, because I'm also planning to come. I know Mr. Chaudhary will finish tomorrow. It seems to be at least that indication. Do we have others who are going to argue on that? I don't know if Mr.
Yes,
Chaudhary.
nobody has said no till now.
Fair enough, Lordship. That's a fair assessment.
May I make a request, my lords?
Just record the presence of whoever is present.
May I just make
Council, yes.
a request, my lords, sir. Tomorrow, my lords, I have some pressing matter, my lords. It's a part-head matter list, specially fixed. I have to be there. If I may get my turn day after, my lords, half an hour, I'll take it. I'll come back tomorrow at night, my lords. I'll go back today and come back tomorrow. It's something I can't avoid, my lords. I'm sorry, my lords, but
Okay. The submissions of Mr. A. Chaudhary, Leonard, Senior Counsel, assisted by Ms. B. Chaudhary, Counsel for the appellant, in WA
14 of
14 of 2022 remains inconclusive. Please to allow him to continue to make his submissions on 21/5/2025. Stop. List of dates and a compilation of case citations has also been provided to the court. The same is made a part of record. Next para.
Volume 2 and 3.
Mr. N. Kohli, first of all, you write the names of the council who are present. Anybody who's present in any matter may get your name recorded in to the court master. They are present in so and so. Mr.
Mine are all with me on VC, Lordship. I'm grateful.
Senior counsel for the state, along with so and so, is present through video conferencing.
Lordship, I'm always requesting for Mr.
Yes,
Ankit
Hazarika.
Roy and Ms. Nimisha Menon because they are assisting.
Mr. S.K. Hazarika is
By
also here.
Ankit Roy and Miss Menon.
Ah,
Mr.
No, it's okay. Their names are there in the Present, next paragraph, lists as part of matter on 2/05/2025.
I'm very grateful.
Grateful lordship, ladyship.
They have 21st করব তাহলে any listing হবো
Single bench, item 1.
We have not received it. They were supposed to file an affidavit.
Actually, today, now they have signed some MOU, my, by the private respondent with my petitioner, madam. So,
We have,
I think by.
we have no knowledge of the same though.
So most probably by tomorrow they will confirm. Today they are filing it, but on record it will be difficult to come by. I understand.
The division bench we are hearing a pattern matter.
Yes.
We'll take it up next Monday then.
Next Monday, yes.
Mrs. Hazarika, any difficulty?
Monday is fine.
Monday is okay. Okay. Also is represented. Mr. P. Kotoge, Leonard Counsel for the review petitioner submits that an affidavit is being filed in course of the day today. Full stop. Next, however, Mrs. M. Hazarika, Leonard Senior Counsel, along with the Leonard Instructing Counsel, has submitted that till now she has not been served with any copy of the affidavit. Next, be that as it may. On the submissions made by the Learned Counsel for the petitioner, the matter stands adjourned today. List on next Monday, make it
26/5.
What is it? Okay.
Okay.